Yes, your officers are there. Your officers are there.
Yes, not my officer.
Okay.
Division bench item 1 with 2.
Look, this is the. I have already given them copy. But on 22/9/23, Lordship has passed several directions, and in response to that, the first letter we have stated that a meeting has been held under the chairmanship of the Chief Secretary, and the departments, all the departments, they have been instructed to give their response as regards the rules by Monday, that is yesterday, and I'm told that the response has come, and now it will be done shortly. That is the direction in paragraph 10 of the last order, 22/9/2023. And secondly, the next page, page 2, the petitioner has given some suggestions. To those suggestions, we have responded, and we have already given them copy.
Okay. We don't have the updated book because I got the updated book for myself. It is Juvenile Justice Care and Protection Act.
Yes.
And I found that there is more than 200 amendments.
Correct.
In last 1.5 years in the central model rules.
Yes.
Now, if the state government has some difficulty in making their own rules, they'll have to issue a notification adopting the amended.
In fact, I'm told that my officer has informed me that the amendments have been they have taken care of. Those have been considered, and with the help of the in page 2, page 2, kindly see para number 8. We have mentioned to accelerate the process for notification of the juvenile justice rules and child protection policy. The department has sought the opinion of Sri Anant Asthana, child rights lawyer, Srimati Gitanjali Ghosh, assistant professor of National Law School, Assam, and Sri Lakshmi Narayan Nanda, UNICEF child protection specialist, for compiling the juvenile justice rules. A discussion with all the concerned was held on 3/10/2023 through video conference. They have also taken up the
And second part of the order.
you can sit down. Page 4.
Take a chair here.
Page 4. Page 4 is the names we have proposed for the committee. I have presented the papers. Page 4. These are the officers. Lordship has directed to propose the names for the committee.
Mr. Sharma, you are online.
Yes, my lords.
You have got this note.
We have no problem, my lords. Your lordships have basically, there are 6 directions in the last order of the 29th of September, my lords. If your lordship permits me, the first direction is in para 4. My lords, we are giving 2 names from our side, my lords. I think Mr. Nihal would have it, my lords. He would pass those names to your lordships, my lords. That is one. And as far as these names are concerned, it's for your lordships to decide, because it is a committee which is to be to assist your lordships. So it will be more of an amicus kind of a body. So we have no objection at all in any of the names.
We'll just look at the names.
Yes, ma'am.
Okay,
What are the credentials? What are the credentials of these two people?
Babita Saikia, she is a child right activist who has been working in the state of Assam and associated with our organization for more than 6-7 years.
Okay.
I have also personally interacted with her. So although the other gentlemen, I have not interacted with Rishi Khan, but Babita Saikia has been working with this organization, this petitioners, for a long time.
You've seen the names.
yes, I have taken up I have discussed the names with my officer. But as regard this, maybe.
I'm told Rishi Kant is also a very profound name as far as this child rights area is concerned. He is one of the co-founders of an organization called Shakti Vahini, who has been instrumental in rescuing several children in various places, in prostitution dens, etc., all over the country. So he is also quite a celebrity of that sort, as far as child rights are concerned.
Only I have just we are discussing about he is from Haryana.
That is what we are thinking. We are also considering only that. The cost factor for him to come here
and the time
and
also,
visit the all
we have 93 such homes.
I think we'll go by Miss Saikia.
Yes, Malad.
She's from the state and would understand the requirements better.
Very well, Malad. I have no difficulty. Lordships will choose.
From Haryana would be entailing huge cost.
Malad, he will. I mean, we had put this to him, Malad. He is a passionate person. They have done a lot of operations as far as West Bengal is concerned. He had indicated, Malad, my assisting counsel is sitting next to me. He would, Malad, be very happy to be a part and contribute, Malad, to the state on his own expense, Malad. There is expenses should not be a concern. And today, Malad, after last Friday's hearing, everything is supposed to be online, Malad, so that there will be no difficulty, Malad. Everybody has access today, Malad.
Okay. We will consider that, but
yes, Malad. Yes, of course.
We would in number one.
Gotcha.
But we'll discuss and then we'll inform.
Then your Lordship sees your Lordship's instructions in para 7 of the last order. Lordship had directed the state government to, Malad, give a report or a reply to the various issues that I had pinpointed in the chart. Now, as far as the Women and Child Development Department is concerned, in the reply that they had filed yesterday, whatever was required of them or whatever pertains to them, they have replied. But there are several other departments which were to do a lot of other activities or rather issues. Those responses have not come, That's one. Then, para 8, your Lordship has indicated about the juvenile justice rule and policy. My learned friend has already indicated that the committee has been appointed. Now, para 9, my lords, they have indicated that there is a meeting. And my lords, then para 11 of the order, Union of India was supposed to file a reply. That reply is not on record. And in para 18, State of Assam was supposed to submit a report after conducting an audit. Now, even that is not there.
If your lordship will permit, lordship there. Children who
Yes, Mr. Chaudhary.
Lordship, in fact, there were 3 directions for the central government, Lordship. The policy enforced through which they are funding these homes and other children protection activities. Details of fund which have already been disbursed, and compliance report, if any, collected to ensure that the funds provided have been properly spent, Lordship. And of course, the names to be suggested. Lordship, I have not received any response as on date, Lordship. So far as the monitoring committee concerned, Lordship, it can go ahead, Lordship. In the meantime, I'll file a affidavit on the 3 main queries.
And you are proposing any names?
Lordship, so far from my panel, I can propose a name, Lordship. I can propose the name of Mr. Harish Gupta. He's from my panel.
Mr.
Harish Gupta.
He'll be prepared to visit.
Lordship,
Okay. That would be a welcome, because if a lawyer is there, we'll
Yes, sir.
understand him more than others.
I'm told that MS Babita Sakya, she is also a lawyer.
That is
The
good.
name proposed by the
That is good. It will be better
she's a lawyer.
for.
But as regard the para number 18 of the order, we have placed 2 letters at page 9 and 10. As for the audit, social audit, we have approached the TIS and they have also agreed to do it.
Very good.
Page 9 and 10. They said tentatively they will take 6 months time. Only the financial part they have to clarify.
If Tata Institute is ready,
Yes,
it's nothing like it.
they are agreeable to do that. They have already given the consent.
But then again, the ball is in the court of the government. Because when they will sign the agreement is again a very difficult task.
I have also asked them. We are ready. Only the final response from the Tata, because the TIS Guwahati has to take the approval or consent from their head office. That is under consideration, and the timeline and the financial part, they have to tentatively they have said 6 months, but there are 93 the homes they have to go and they have to visit a lot. So exact timeline and the financial part, and I have asked my officer a lot. The financial part is not a problem for us.
Administrative process to.
ইয়াৰে টাটা গুৱাহাটী এইটো গম নাপাওঁ নহয়। সিহঁতেতো এইটো যিটো এষ্টিমেট দিব ছ'চিয়েল অডিটৰ তাতেই থাকিব সেইটোতো বৰ্ডৰ বাইদেউ
Names of alternative names of members of proposed committee.
Okay, in this in respect of this direction at serial number 4.
Malan. Yes.
Just see, heard Mr. P.P. Sharma, Leonard.
One further submission I have.
No, just one by one.
Lot.
So we are first in paragraph 4.
It's just recording.
We are just recording so
Lot.
that it's over and we
Lot.
come to the next point.
Mal.
One by one, we'll take it up.
Yes.
So we are right now on 4. You have
No.
suggested names. One name suggested by Mr. Sharma, and the other is the Union of India, Harish Sharma,
Lot.
Harish Gupta. So we are
Lot.
recording that one by one. We are
Lot.
coming to it. Otherwise, I'll forget the track.
Lot.
Learned Council, along with through video conferencing, along with Mr. N. Chaudhary, Counsel for the petitioner, also heard Mr. D. Nath, Learned Senior Government Advocate appearing for the state, Mr. N. K. Sharma on behalf of H. K. Das, Standing Counsel for this court, Mr. R. K. D. Chaudhary, Learned Senior Government, DSGI for the Union of India. The names of the officers, kindly write it down. We'll incorporate in the order.
Designation.
And designation, the name of the officer and designation.
Lot.
All those officers were there. We'll record their names. Next pair. On 22/9/2023, this court had issued certain directions in this matter. Full stop. In respect of directions contained in paragraph 4 thereof, the Learned Senior Government Advocate has placed on record communication dated 5/10/2023 from the Secretary to the Government of Assam, Women and Child Development Department, proposing the names and designation of the officers for appointment as members of the High Court Notified Committee. So the names suggested are as follows. Yellow flag. Page 4. Stop. The Learned Counsel for the petitioner has suggested 2 names. As the name of one of the names suggested is a resident of Haryana. We deem it appropriate to appoint Ms. Babita Saikia. Okay.
Vijay, can you? Two names, sir. Out of it, we'll accept this.
Whose name and particulars are also incorporated in the list. Full stop. On behalf of the Union of India, or the learned DSGI has suggested the name of Harish Gupta, learned CEC, to be a member of the said committee. Full stop. Therefore, the fully court approves the name of 7-member committee to be members of the High Court notified committee to
It was here to visit.
would be required to
Paragraph 5.
visit various children, observation, special homes in the state, and also to see and report if there is proper implementation of various directions and or children right laws, so as to ensure that the various directions contained in the case of Sampurna Behura versus Union of India 2018 4 SCC 433 are complied with. Full stop. This is one.
Now paragraph 7.
Now paragraph 7.
If he may add 11 proposals, Mr. Sharma may address.
Mr. Sharma, on this
Yes,
proposal,
Manoj.
what do you have to say?
Yes, Manoj. Manoj, as this, in our chart that we had given to your lordships, and your lordship had indicated that all the respondents give their comments, and my learned friend was to collate all of them. The affidavit that has been filed yesterday night, Manoj, gives the response of the various Manoj dues that were required by the Women and Child Development Department, Manoj. Those have already come. But the dues that were required from the other departments, Manoj, they have not responded.
In fact, Malad, I'm about to pray that in respect of direction given in para 7, Malad, things are still coming up, Malad. Malad, I have to compile, Malad, because at this stage, whatever information I have, those are not complete, Malad. So lordship may give me time till the next day, Malad, so that I can compile, Malad. So things are coming up, Malad.
Okay.
Very well, of course. Well, it's not an easy task. My learned friend is already given a lot of assistance, Manoj.
Correct. That has to be appreciated.
Yes, Manoj.
In fact, things have become clear after your chart.
No, I'm so grateful, Manoj.
It's very easy now to understand what is
Precisely
what we are handling.
precisely we can point out that this has to be done.
Huh.
That charge has, to that extent, it has helped us.
Yes, yes. Otherwise, when we were reading the brief, we both were at a loss of words how to proceed.
Correct, Malad.
So that Mr. Sharma has done wonderfully.
No, I'm so grateful, Malad. I could be of some help to your lordships, Malad.
It has
And your
been,
lordship has been very, very proactive, Malad. In fact, I was initially of the view that Karnataka was the leader when Malad Justice Oka used to be the Chief Justice. But now I can proudly say that my home state is the Malad's most proactive as far as the implementation part is concerned, Malad.
And we just remembered dialogue from a Hindi movie where it says Mugambo Khush hua. Okay. Insofar as directions contained in paragraph 7 of the order is concerned, comma, the learned senior government advocate has provided the response from the Women and Child Development Department, which is signed by the Deputy Secretary to the Government of Assam of the said department. Full stop. In this regard, the learned senior government advocate prays for some further time to obtain comments from the other departments. Full stop. The prayer is considered and allowed. The response of which departments?
Followed, apart from women and child, home is there,
Home.
Home
Home department
and the judicial also. Judicial department.
and the judicial department. This education was also required.
Education, they have already given their views as regard the rule is concerned.
Okay.
They have already given.
They have given.
Yes, they have given. Because the meeting was held under the chairmanship of the chief secretary
Okay.
and all the departments are there, they have already given.
Okay. Do they have a plan? Because since we have not gone through it, do they have a plan to provide facilities for education, appropriate
Well,
education to this?
Because it has come yesterday. What is that? I don't know.
Okay.
I have no idea.
Due to interact with those education department, what is your idea? Have you interacted with the education department in this regard? Come to this side.
My lords, regarding the rules, lords, we had a meeting with the Chief Secretary Assam, and the views were pending, and they have been asked to submit it by Monday. I have come to know that they have submitted informally. Officially today, we are going to get the signed
Okay.
copies.
Okay.
So we'll.
No, because I'm asking you for a reason. You are under the amended JJ Act. Now the education is also a part and parcel of their rehabilitation process. So when you have a discussion with those officers, please keep in mind the amended juvenile justice rules. Those amendments have come between 2021 and 22. So please keep that in mind, the updated rules, so that when you interact with those departmental officers, you get the updated information as per the amended model rules. Please keep that in mind.
Well noted.
Okay. And any other concerned department.
Not.
Okay. First off, in this connection, your designation,
Deputy Secretary to Government.
the Deputy Secretary of the Government of Assam, Women and Child Development Department,
This is
Come on,
the
who's-
number one, Malad, at page 4.
who's present, has submitted that in a joint meeting of various departments held in the office of the Chief Secretary on 7/10/2023, various departments have given their view, which is for which the formal views were called for. So it is submitted that the education department has also given their views on the model rules for the state, right? Okay.
Officially will be received.
Huh?
Officially will be received.
No, it's okay. I have said that.
Not.
I've said that, but it is with regard to the rules. Their comments is on rules.
Rules.
Okay. Okay.
Model rules.
Okay.
And they have said that also the amendments are being, they have considered.
Okay.
All the amendments have
And they have and they have also considered the amended model rules.
Logic.
Okay. Next paragraph. We would request the Women and Child Development Department to expedite the process for early implementation of the child protection laws in the state of Assam. Now, now next paragraph.
Complied with, paragraph 9 is complied with.
Para 8, Manoj, I had a small suggestion, if it meets your lordship's approval, Manoj. In para 8, my learning, in the response, they have said that they have consulted Manoj, Mr. Asthana and a couple, Ms. Gugoi from the National Law School, Guwahati, Manoj. Manoj, as far as we are concerned, it's the Bachpan Bachao, Manoj, we were instrumental in drafting the model rules, Manoj, and we assisted the central government. The Uttarakhand rules, the Gujarat rules are also, Manoj, framed with our help. If the state wants the help of the petitioners, Manoj, we are more than happy to assist, Manoj, because whatever is happening across all states, Manoj, the petitioners are aware and completely, of course, pro bono. There is no question of any, Manoj. It is only for the benefit of the whole society as such, Manoj, nothing else. If they want to take our help, Manoj, we are more than willing.
You can include them in the. You can include them in the suggestions for the draft.
Malad.
It did not,
The learned counsel for the petitioner.
The department can also have a meeting discussion with video conferencing mode, in the video conferencing mode with the petitioners.
Yes.
Okay. Yes.
Lordship.
We will permit that in our order. With regard to the process which has been initiated for notification of the juvenile justice rules and child protection policy, the State Child Protection Society, Assam, has submitted in its report that this department, which department? The department has sought.
They are under the Women and Child Development.
No, because this letter is by Child Protection
Child
Society. They
Protection
are under.
Society, but the department is Women and Child.
Okay, okay. The Women and Child Development Department
Lordship.
has sought for opinion of Sri Anant Asthana, child rights lawyer, Srimati Gitanjali Ghosh, GEETANJLI Ghosh, assistant professor, National Law School, Assam, and Sri Lakshmi Narayan Nanda, UNICEF child protection specialist, for compiling the juvenile justice rules. The learned counsel for the petitioner also suggests that their representative can that the Bachpan Bachao Andolan is also ready and willing to nominate their activist to assist in the process of notification. He has also submitted that the petitioner society was instrumental in activating activating the Union of India as well as various states in the country for implementing the child protection laws. He has also submitted that their assistance would be pro bono in view of the suggestion which has been given by the learned counsel for the petitioner.
Which has readily been accepted by the Karnataka Society.
Accordingly, we are inclined to direct the government of Assam, especially the Women and Child Development Department, to have in their panel person nominated by the Bachao Andolan, the petitioner herein, to accelerate the process of notification of the juvenile justice rules and child protection policy. Stop. If required, deliberations can be done by their representative through video conferencing. Okay. Now we come to
9 is complied.
9 is complied.
Yes, 9 compliant.
If the village government
Okay.
agencies,
In respect of paragraph 9, the learned senior government advocate has submitted that a joint meeting has already been convened in the office of the Chief Secretary, Government of Assam, on 7/10/2023 at 11 a.m. and the state, and it is submitted that the state is doing the needful for accelerating the process of notification of the juvenile justice rules and the child protection policy. It is submitted that the reports from some departments are awaited, which will be complied by the which will be compiled for production before this court on the next date. Mr. Nath,
Hello.
the same compilation, no need of affidavit. The response which we are getting,
Hello.
you give it in form of
Not-
this.
Lordship, we will not file affidavit, but in the compilation. we will provide.
We
Lordship.
dispense with the filing of affidavit
They up to the
by the state for producing the compilation of response by the various departments,
Malad.
which will be submitted by the learned senior government advocate. Now, 11 funding back. Okay, you need some time. 11. How much?
Lordship, let it be immediately after the vacation, but I would request your Lordship to make some observation, Lordship, because they have at least to respond, Lordship.
We have already had a meeting of mind to do that.
Lordship, because simply informing them.
We've already made our mind. On a query with regard to implementation of the directions contained in paragraph 11 of the order dated 22/9/2023, the learned DSGI has submitted that he has already written to the concerned authorities, but their response is awaited.
On 23/9, I have.
Written on 23/9/2023, but their response is awaited. Next para. The appropriate government in the appropriate department in the government of India, including women and child development and other departments associated with child welfare schemes, shall take a note that this division bench has been specifically and specially constituted to oversee the implementation of the direction of the Supreme Court of India in the case of Sampurna Behura within bracket Supra. So therefore, we expect that the government of India to take a keen interest for the implementation of the child protection laws in the state of Assam in right earnest. Full stop. The directions contained in paragraph 11 is quoted below. 11. Next paragraph. Therefore, we expect that the Union of India shall do the needful as per the directions contained in paragraph 11 quoted above. Stop. The Union of India is also put to notice that on their failure to respond to the said directions will compel this court to summon their concerned secretary level officers to the court to ensure that the directions of the court will be complied with. Full stop. In this regard, the learned DSGI shall transmit a downloaded copy of this order to the competent authorities, and on the next date, he will provide us the list of officials who are at the helm of affairs in the Union of India on the implementation of child rights, rights, specifically, and the persons responsible for responding to paragraph 11 of the order dated 22/9/2023. Next para. We also direct all the learned counsel for all the appearing parties to exchange their filings, whichever are being made in this matter, with each other, so that on the next date, the stakeholders are prepared to make their submissions in the matter. Stop. The court permits the state government officials as well as the learned counsel for the parties to address the court by way of video conferencing on the next date, if so advised. Next para. The Secretary to the Government of Assam, Women and Child Development Department shall depute one of its officers to be present in the court when the matter is next. Oh, achha, 11 para 11 next. In respect of directions, observations made in paragraph 17 of the order dated of the said order, comma, the learned senior government advocate has submitted that they have had a principle, in principle, approval of the Tata Institute of Social Sciences, Guwahati campus, to conduct the study to conduct the social audit. Full stop. In this regard, the learned senior government advocate has submitted that some time would be taken for finalizing the modalities and for signing of the, what is TOR? Terms of reference.
Terms of reference. Gotcha.
Terms of reference.
Gotcha.
And in this regard, the learned senior government advocate seeks some more time to engage Tata Institute of Social Sciences, Guwahati campus, to do the social audit. Stop. In view of the copy of letter dated 4/10/2023 of Tata Institute of Social Sciences, Guwahati campus, the time as straightforward is allowed. Stop. The updated development in this in the issue of social audit shall be informed to the court on the next date. Yes.
That my lord, we can if they respond to us, particularly that two things, we can give the order.
No, you can proceed with it.
Correct.
If the modalities are finalized, the Government did not wait for the approval of this court to go ahead with the conducting of social audit.
They will try.
Then that paragraph and then list on
But
suggested date.
one query I have, Malad, just the committee is to be appointed by the honorable court, the names we have proposed. Terms of the committee and expenses, Malad, has you got any idea, Malad, just
Who else? You are the mighty state.
that is what
No, if you-
that is what Malad, we want to.
No, we have an alternative.
Lodge.
If the government appropriate authority permits us to print money, we'll definitely pay. If that is not forthcoming, then I think it's only the Union of India and you who will have to arrange for funds. You have to finalize it. We'll be happy to assist you if you give us the permission of printing money. More than willing.
The cost of visit only.
No, because this has to be borne by the, you see, we can't envisage a situation. Let us give an example. My examples are always horrible, but it's just an example. Supposing X is a businessman, he wants to do an audit, which is statutorily required under the Income Tax Act or under the GST Act. Now, can he pose a question to the court that, well, who will pay for that?
No, Malad, I'm just on the committee, because the committee, Lordship is appointing the committee, Lordship will definitely take care of that. The coordinator of the committee, how the things will be moved on. That terms Lordship may frame.
Because the secretary is there, she can do it. That thing, they are experienced. The department is experienced. They can tell us and we'll approve it.
Ultimately, somebody has to coordinate among the committee
No,
members.
we
and
leave it on
accordingly
the secretary. She's here.
Malad, names have come. Lordship is now going to pass an order.
We have constituted the from now when we'll add the committee formed. There add one thing. The committee shall meet either physically or virtually within a period of
Proposal given by the company is accepted. Two other members are added. The committee, therefore the committee will consist of the following.
The committee. Who is the member of the committee for the government who are there?
Page 4, Malad. That bunch I have given.
Page 4.
Page 4.
We
have proposed these
You are serial number 1, Dr. Priti Lekha Deka. So I think she would be a better person. She's a PhD, and so she'll be more. What do you call? We find a more appropriate person.
Gotcha.
Although this serial number 5 is also a PhD,
Gotcha.
but since she is in the department, I think she will be a better person to handle.
She will be the best person. She will be the member.
We also propose that the 7-member court-appointed committee shall be headed by Dr. Priti Lekha Deka, ACS, Deputy Secretary to the Government of Assam, Women and Child Welfare Department. The government in the Women and Child Development Department of Assam shall render all assistance to her. Well, discharging her functions as in terms of this order,
and in terms of paragraph 5 of the order dated 22/9.
and in terms of order dated paragraph 5 of the order dated 22/9/2023. including requisite funds and logistic support. Mr. Nath, we have added 2 words that for that the government in the Women and Child Development Department shall give all logistic and financial support.
And Malad, they any guidelines to the committee that in this manner they will do, or
No,
or they will
they'll
the
do it.
modalities they will
They will do it because you see, we don't have the field experience in doing it.
Logic.
And being the secretary, we are expecting that she would have some experience in dealing with these matters.
But since
They will
the
decide.
modalities will be
Model
fixed
will
by
be
them.
decided by
Yes,
the committee.
And since they are having 6-7 members, they may not into 2 groups they can go, or that modality they will fix.
No, we leave on them.
We have 93 Malad, the centers Malad.
No,
So number is
you see, we leave it to the wisdom of the committee.
committee.
They may think that 3 people can go and visit.
Yes.
We always don't need 7 people to go and visit. So it will be the committee who will decide.
Because it is throughout the
Mr.
state.
Sharma is also here and you are also here.
Follow.
We are not penning it down, but please understand what we are saying is that your committee will decide with the matter. If you think 3 persons can go and visit, it is okay. You think that you will nominate some persons to go there. Don't. We are not expecting that you would send peon level people.
No.
Correct. That we are not expecting.
Committee members will go.
Committee members or somebody who are responsible. They should visit. Not any. What you call in usual languages, we say Tom, Dick, and Harry. No Tom, Dick, and Harry business, but respectable officers who can really do their work. They'll have to go, because if their status is below the in charge of the children home, no point sending such person there.
Correct.
It will be your wisdom.
Correct.
We are leaving everything to your wisdom.
Considering the number of the institutions and the number of the members, if they form 2 groups, and that
We are not saying anything. It's up to them.
modalities they will.
It's up to
That is
them.
what just I need to just
It's up to them.
logic. They will do.
Your Lordship is absolutely right. The whole idea is for Lordships to get the information. That is the whole idea of this minutes.
Yes.
Nothing more than that.
Because we are also always reminding ourselves when we are taking up this matter that this is not a adversarial litigation. It is for implementing of child laws.
Logic.
So I think we are all at the same page with each of us.
My
So the anxiety which we are sharing, the same anxiety must be there with the government. Same anxiety must be is always is apparent on Mr. Sharma for the petitioner. So I think we are on the same page. It's not an
Yes.
adversarial litigation. So she will take a call once she is the chairman or in charge of the committee, whatever name.
Logic.
What name do you suggest as a head?
They have named it High Court notified.
No, you will call herself what? Chairman of the committee.
Chairman of the committee.
She will act as the chairman of the committee. She's about to.
It is the headed legislature, as chairman of the committee.
Oh, no.
Is this matter?
Now, suggest a date when we should take it up.
Any Tuesday or Thursday, Malad.
Okay.
If it's whatever date is convenient, Malad. If it is convenient, Tuesday or Thursday, any.
9/11 कर दियो।
And Thursday.
Okay. We are speaking 9/11.
Very good. 9/11.
Can it be on the next week?
Another next. Then it goes next week. Then
16-11.
okay. 16/11.
16-11.
16.
That is fine.
I'm so grateful. It's always a pleasure.
Please repeat again.
Maybe taken up as first item.
No, the first will be taking up the top of the list items. These are 2007 matters. After that,
Then have some problem. Some problem. Not be able to stay back. I have half an hour to this thing. If your lordship takes up, then this will be taken up. After.
no, because this top of the list are 2007
I've
matters.
seen top of the list suspension. In fact, Chief Justice the other day was telling, it's so embarrassing. It's written top of the list, but we cannot take it up. Some cases he had gone.
In fact, I've been trying to take it up.
Only request.
I'm trying to take up top of the list matters in the top of the list.
No, it should be. If it is on top of the list, it should be on top of the list. Now, it will be inconvenient, but next week will be the last week, not be possible. And this week it seems, my lord, for me today, I cannot stay back for long.
But then I can't keep it parted for long.
It's not written parted in any case.
No, because the wordings are that it will be further hearing. So
Yes, it is
it's
there,
fathered.
but we have to mention it because it was not shown as part heard. And because the next order it is not part heard. So, your lord, I have just half an hour to say. So, if your lordship, I'll leave it to you.
No, because then again he will have to make his submission. Once I start, I can't.
I know that
postpone
I don't know whether he'll be able to make his submission today. I have my doubt.
My lord, Mr. Goswami is in the midst of a hearing before Honorable Division Bench 1. He's requested that if the hearing goes on today, may be allowed some other day to respond. Subject to
Then fix it
lordship.
after vacation. We are not saying anything. Let it come after vacation.
I'll leave it to lordship.
You suggest a date, Mr. Mishra? After vacation, suggest a date.
Immediately after vacation, the 9th might not make it.
9th, we have already that division bench matter. Oh, sorry, no, division bench is not there.
That
Okay,
is
9th.
that has gone to 15th.
Okay.
So 9th, lordship will take it
Okay.
up. It will open on 6th.
Joint
9th.
prayer made by the counsel, senior counsel for the petitioner and the respondent. From the magistrates adjourned today. List on 9/11/2023.
It's parted.
I'm not saying that.
No obligement.
Please, with the consent of the other side, I recommend item number 5 and 6 of today's list, my lord. I am for the appellant in the RSA, my lord. I'm praying for retail accommodation, my lord. On behalf
No,
of
all these are old
Senior-
matters. All matters I am not adjourning.
my lord, on behalf of BC Das, my lord, Senior Counsel.
No, I'm not adjourning all matters at no cost.
Kindly accommodate for
No,
today,
no.
my lord.
All matters I am not adjourning. Be there. Yes.
Oblige, my lord.
Yeah, please. I'd like to mention this matter for listing, madam.
Listing? At what stage?
What notice is served, my lord, they have filed Ukalatnama, my lord. And
Okay, give it to the court master.
obliged.
I beg to mention for listing.
What is the urgency before vacation?
Because this revision petition was earlier moved and it was adjourned. And now, my lord, the trial court has ordered for execution. And CRP was filed against the decree of appellate court under rent control act. Otherwise, everything will infectious.
Okay, give it to the court master.
On Friday or Thursday.
I'm not saying he will give a date, but you give it to the court master. Give it to the court master.
Please, Lordship, I beg to mention 2 items. One item is IA for injunction in an RSA pending RSA. It may be listed on Friday, my lord.
What is the urgency?
My lord, during the pendency, they are starting threatening to evict us
Give it to the court
Friday,
master.
and the other one is RSA, my lord, next week. It was listed in June. Till date, it has not been listed. Returnable in 4 weeks. My lord. Next week.
Let it come after vacation.
Injunction, my lord, Friday.
No, not Friday. I'm not saying that. The court master will fix a date, but I am allowing you to give it to the court master.
May I please, Your Lordship, I beg to mention this matter for listing. This a compromise petition has been filed, matter has been amicably settled.
I beg to mention item number 2, my lord. This
No,
case,
no, no chance.
In this case, my lord,
No chance.
Mr.
We'll adjourn it only at the
Dean
payment
is
of
with my
2 lakh
colleague,
rupees as
my lord,
cost.
HK Ahmed, my lord, and my lord,
If for 2007 matter, 9 matter we are
the
adjourning.
Mr. AM Mazumdar has been
You-
expired, my lord.
If you are ready to deposit 2 lakh rupees at cost, we'll allow.
Mr. A. Sidri is not positioned to argue this.
No,
case,
no,
my
no,
lord.
no.
So that
You
they have
may
tomorrow, my
assist,
lord.
you may assist us, you may not assist us.
Yes, sir.
We'll take up the matter. If you pay 2 lakh rupees as cost, out of which 1 lakh rupees will go to the legal service authority.
A. Sidri is not in a position to
No,
argue
no,
this
no,
case,
no.
my lord, as
It's
because
no
my lord, his,
adjournment.
Uncle has been expired. my lord.
No adjournment. You may assist us, you may not assist us. We'll take up the matter. All matters we are not adjourning.
Item 15, top of the list, delivery, item 15 for delivery of orders. No, item nothing.
The appeal fails and the same is dismissed. Let the decree of dismissal be of appeal be prepared. NCR be sent back. But this is a case I am not very happy to dismiss.
I have understood. Even we were discussing like that. Putting below the knee would have been a better option.
Huh?
If at all required. Shooting below the knee, making him temporarily injured, etc. They could have, if they at all wanted. We were on the.
No, I don't know since I have closed this matter, but
after the,
I'm not happy.
Understood. Even we are also, I have to defend. Then it
No,
appears
that is true.
technically it's all right.
This is a case. Means I can only say to use not as a person who is holding a brief or who has been briefed, but as a member of the bar. I think time has now come for the bar members to upgrade their civil skill. Civil skills. Civil skill in trial court.
And particularly in the trial court, because once the mistake occurs in the trial court, it's very difficult to cure.
So earlier,
and in this case, as your office is pointing out, there were
earlier this bar from where this matter has come was a very rich bar in civil service.
Earlier also, Lordship said they boasted rather.
Huh?
They earlier boasted of having a very.
No, I'll not use the word boast, but it was a good bar.
It was.
So civil skills.
And after that generation has gone, my lord, things have changed actually. We have noticed that. new generation possibly. They
I
are,
can only request the bar associations of district level
Madam.
to upgrade their skill on the civil side of advocacy. That's the only comment I can make.
Item 1, top of the list.
Yes.
One suit was for right
You are the
title.
plaintiff for the defendant.
I am the defendant. Suit was decreed. Appeal. It was upheld. Suit was for right title, interest, and partition.
That's it. Evidence Act.
Regarding 90 of the evidence. Presumption regarding 30 years old document.
Yes. This exhibits were introduced in evidence by whom?
By the defendant.
No, which PW? Which DW?
DW4.
DW4.
The originals are with the files, the original record, the
Wait,
original
wait.
exhibits. Some of them are some British era documents.
Please read the prayer in the plaint.
In that page. That page 34. The plaintiff title on declaration respect of 1 bigha 1 kata 16.5 lesser out of 2 bigha 3 kata 14 lesser land schedule for and respect of 14 bigha 1 kata 3 8.5 lesser share of the other land of the schedule for other than the land of schedule for be declared and primary decree or partition issued in favor of the plaintiff and for issuance of separation of pata in favor of the plaintiff. Having to be appointed over the execution of correct decree of partition. As possession. Declaration title.
So suit for partition and
declaration.
Declaration, partition, and then khas position.
Khas position.
This in your written statement, where is the reference to this for sale deed?
My lord, paragraph 13, my lord, reply to the paragraph 7, page 41. Page 41. That the statement as made in paragraph 7 of the plaint that the plaintiff's father Lakhikanta and mother Rosupriya had not transferred any land under their share to anyone in any manner is not true. In order to repay his loan due to financial strains and to make his medical expenses, sold his land to others. He had sold his land to the answering defense's father Tarakanta on 4435 and 3841 and to the defense number one's father Santiram on 7/11/1941 and that was on basis of the said sale Santiram and Tarakanta obtained their mutation in their on their death. Mutation passes on to the defense number 1 and defense number 10, 11, 12. That is a specific one of statement made by pleadings by the defendant.
There is a reference to only one sale deed. কেতিয়া ভাবে কারণে বিভিন্ন যোগানে সারি সারি পঁয়ত্রিশ এখানে বিবাদী পিতৃ okay. Please count how many cell deeds are referred to. 441. Second is 38 41. 11141.
One is 4435.
4435. Other is 38 80 41.
41.
One
and
is 11141. Another is.
And that was the in Assamese manner 28 2.
I'm reading in Assamese only. I'm reading from the LCR.
4.
4.
Although Leonard trial court my lord held that it was come from proper custody, but refused to accept this exhibits. And that is a substantial question of law which was formulated by the earlier under section 90 of the Evidence Act. My lord.
Yes, Mr. Das.
Yes, my lord. According to
Why
the-
these documents would not be admissible?
Yes, my lord. My sir. My lord, they have, the defendant appellant has submitted that they have purchased the land. But how much land they have purchased, it is not specific in their pleadings. By which document they have purchased, it is also not specific. Your
But
Honor.
it's there, we have seen
And
that.
My lord, only dates is given, but document was, no deed number was mentioned in their pleadings.
No, no, why not? We are reading that.
My lord, more than 94 because of land are concerned in this suit, my lord.
No, no, you see,
My lord.
because para 13 of the written,
And my lord,
written statement.
Regarding my lord, why the learned trial court below did not,
No,
did not
because you see-
accept their submission, did not consider their submission, my lord. Because according to section 90 of the Evidence Act, the documents which are 30 years old, my lord, required to be presumed as genuine, my lord. But in this case, the documents were not presumed as genuine, my lord. Because according to section 90, my lord, the court may consider the 30 years old document may presume as genuine, my lord. The word may is there, my lord. And it is not compulsory, my lord, or mandatory. It is only discretionary, my lord. The court may or may not accept the document as genuine according to submission, my lord. In the evidence on affidavit, my lord, the defendant number 1 and 2 as PW1, DW1 and 2 has submitted evidence of their evidence on affidavit, but they did not turn up. They were not cross-examined, so their evidence is gone, my lord. Defendant number 3, DW3 is an independent, and 4 is the defendant himself, my lord, now appellant, my lord. During cross-examination, what he has stated, my lord, that it is important, my lord.
Yes.
May I read, my lord? শপথ পত্ৰৰ 11 নম্বৰ just first paragraph, second, just after third paragraph,
Witness
my
number
lord,
4.
of DW3 4 cross, my lord.
DW4, yes.
Cross 4 শপথ পত্ৰৰ 11 নম্বৰ দফাত, yes, my lord, third paragraph of my certificate. বালিগাঁৱত থকা আমাৰ অংশৰ মাটি বিক্ৰী কৰা নাছিল। নাই, yes, my lord. So লক্ষীকান্তৰ মৃত্যুত মোৰ জন্মৰ বহুত বছৰ আগতে হৈছিল। লক্ষীকান্ত is our father, father of the respondent plaintiff. শপথ পত্ৰৰ 11 নম্বৰ দফাত লক্ষীয়ে মাটি বিক্ৰী কৰা বুলি লিখিছো, যদিও উক্ত সকলো বিলাক দলিল আদালতত দাখিল কৰা নাই, আৰু দাখিল কৰাৰ বাবে মই আদালতত কোনো তদবিৰ লোৱা নাছিলো। During cross examination it comes, my lord. আৰু তাৰে কেইখনমান দলিল অৰ্থাৎ তাৰা আৰু শান্তিৰ দলিল দাখিল দিছো। এক্সিবিট জমবন্দীৰ কপি, পিতা লক্ষীকান্ত শৰ্মাৰ নাম 2 নম্বৰ লিপিবদ্ধ হৈ আছে। এক্সিবিট 23 লক্ষীকান্ত শৰ্মাৰ নাম 4 নম্বৰ পত্ৰদাৰ হিচাপে লিপিবদ্ধ কৰা আছে। এক্সিবিট 24 লক্ষীকান্তৰ নাম 4 নম্বৰ পত্ৰদাৰ হিচাপে লিপিবদ্ধ হৈ আছে। So my name stand, my lord. They have filed a mutation case, my lord, for mutation of their name. That was also cancelled, my lord. Sorry, ma'am. That is not. বাজির মাতৃর নাম বসুন্তিয়া। এক্সিবিট 4 বাজির মাতৃর নাম 7 নম্বর শোন। Name of all the plaintiff and defendant are there, my lord. That means appellant and respondent. This is, they have, according to him, they have not produced all the documents. Next, my lord, PW3 cross part, my lord. Baji Ramesh. First character is maybe split up. More hopot but married, my lord.
Okay, just a moment. The first sale deed, it is 3 kata 10 lechas.
Yes, ma'am.
Now 3 kata 10 lecha jumi 2 বা 3 শতাংশ অংশ। তিনি পোৱা। But this is not a what you call original registered sale deed.
No, it was not required because it was before the Registration Act, my lord. In 1941, 36. And also, my lord, the partition, my lord. Partition deed also exhibited, my lord, exhibit A. Here is my case is that, my lord, the father of the plaintiff has sold us some of the land, my lord. He is not entitled for entire land, my lord, which was sought for partition. That was my case, and therefore, my lord, we have submitted these documents of sale deeds, and this was discarded by the trial court as well as by the appellate court without giving any reason. Although it was finding was that it was come from proper custody.
Reason is there, my lord. Specific reason is given by the learned trial court, my lord. At the time of deciding the case, my lord. That is why I am going to read the cross part of DW 3 and 4, my lord.
Just make the calculation how much land is it comes to this four sale deed. Okay, you continue dealing with that cross examination. Exhibit process of লক্ষ্মীকান্তৰ নাম 1 নম্বৰ পাতাদাৰ হিচাপে লিপিবদ্ধ কৰা হৈছে আছে।
Evidence of DW4.
Cross examination. He read till 23. I'm reading 24 to 25.
Hello, in the paragraph 11 of the DW4, it was mentioned, my lord, the tally has been given. DW4, paragraph 11.
Eleven बीघा 1 कटा 18 लचा।
Total, my lord, it was 11 with a 1 kata 18 lecha. So So out of that, my lord, we have exhibited some of the, not the entire cell deeds, my lord. Some of the cell deeds we have exhibited, my lord. Because we are not obtaining those other cell deeds, whichever we have, my lord, the old document we have exhibited before this honorable court. And it was calculated like this. They have not denied this part, my lord. In the cross-examination.
What the learned trial court below did not accept that their pleadings, my lord, as correct, my lord. Only because that they have not corroborated.
The basis was made in the WH check,
No,
my
you
lord.
see, please give me a suggestion how 1941 deed will be corroborated.
My lord, yes, my lord. That plaintiff has defendant, as DW4 has stated, they have not taken step all to bring out all the document before the
That is okay.
learned. Yes,
But
my lord.
11 Bigha is
Next, my
present.
lord, DW3, my lord, during cross-examination, he has stated, my lord, that he does not know how much land or who purchased the land. He does not know, my lord. That is, I am going.
No,
to,
did he exhibit those cell deeds?
my lord,
Did he exhibit those cell deeds?
I have not exhibited.
No. DW3.
DW3 has not exhibited any cell
So
deed.
therefore, he will not submit that.
Yes, my lord.
You
But-
see, if I am not exhibiting a document, if you cross me on that document, how will I know?
But according to him, DW3, that he knows that the defendant has purchased their father or they have purchased the land from Lokhikanta Sharma, my lord. But when he was cross-examined, my lord, that part, my lord. That part, my lord. মই মোৰ শপতনামাৰ 3 নম্বৰ দফাত লক্ষী শৰ্মাৰ অংশ 11 বিঘা মাটি বিক্ৰয় কৰা বুলি মই লিখিছো কিন্তু সেই বিক্রির কথা মই নাজানো নাই they have written in their evidence on affidavit he has but he does not know my lord next my lord শপত পত্ৰৰ 2 নম্বৰ দফাত মই 4 কথা 12 লেছা মাটি খেতি কৰা বুলি লিখিছো তাৰা শৰ্মা আৰু ভাইগনৰ মাটি কিমান আছিল মই নাজানো তাৰা শৰ্মা লক্ষীকান্ত শৰ্মা brothers my lord but he also do not know. So that is why, my lord, the learned trial court below, my lord, did not accepted that the documents documents which are more than 30 years cannot be presumed as genuine, my lord. They have specifically give the reason. Learned trial court has given the reason, my lord, regarding the non-acceptability of the document at the judgment, my lord. I may read it, the operative part, my lord. DW3, page number 22, my lord.
Just a moment.
Memo appeal, my lord.
Just a moment.
Married, my lord.
These are cell deed of which year?
Yeah.
41, 35, and 41.
Yes,
the registration was required at that point of time also. If it is not registered, it can't be read into evidence. You otherwise also fail. You said that it is not required to be registered, but it is required to be registered.
Required to be registered, my lord.
What is the value of what is the value given in the cell deed?
Are we below 100, my lord? At some time.
Second salary is 86 rupees.
Below 100 rupees.
First, I can't read. Third deed it says Usit Mulya.
Okay.
The first deed I could not read the money. It's torn. Second deed says 86 rupees. Third deed says Usit Mulya. The value is not given unless you read it. I don't.
I don't have the original copy. My lord. Originals are
I'm
before
unable
lordship,
to
my
read
lord.
that.
And to see, my lord, whether the registration was compulsory at the time of, my lord, incorporation of the act, my lord. জমি 15 টকা 15 টকা
15 টাকা. First.
15 টাকা বললাম, 15
Okay.
rupees.
Second is 86.
56. It is exhibit B is 15 rupees.
Second I can read it is 86.
Second.
Third deed
56.
Second.
The exhibit B.
One.
third deed
One is 15 rupees.
third deed I am reading it Usit Mulya.
18 টাকা. Exhibit B is
18 টাকা Usit
18
Mulya. Okay. So okay. Not required.
No, it to exhibit B. Exhibit B 18 টাকা. Exhibit B 45 টাকা. Exhibit E 45 টাকা. So below 100 rupees. So issue is that, my lord, whether that is admissible or not, that is the issue. My lord. And the learned trial court as well as the first appellate court, my lord. First appellate court, my lord, did not discuss anything, my lord. Whatever the first trial court has discussed, my lord, the first appellate court accepted that and dismissed my appeal, my lord.
First the law on section 90.
In section 92 parts, my lord, first court has to hold, my lord, it is come from the proper custody. And if it come from the proper custody, court can presume the correctness regarding the signatures and the authenticity of the other things, my lord, has to be may presume by the court, my lord. If court may not presume, if it was proved otherwise, my lord, if anything supported by the other party that it was cannot be presumed, then court may not presume that it was not genuine. But on that count, my lord, there must be some pleadings that those documents were not genuine as claimed by the parties. My lord. There's nothing on this case, present case, my lord. They have not said that the cell deeds were not genuine regarding the contents and the signatures, my lord. Although the trial court held, my lord, this comes from the proper custody. So it fulfilled the section 19 first part, my lord. But on the second part, my lord, full that it was may not be, my lord, genuine, my lord. It's not because the defendant did not adduce proper evidence, my lord, and pleadings. That was wrong, my lord, because we have in the paragraph 13, my lord, in our WS, we had pleaded the basis, my lord, on for these documents. Regarding that part, my lord, I would like to draw your lordship attention, my lord, a trial court judgment, page 24, my lord. Trial court judgment that was discussed, my lord.
My lord, we have specifically mentioned that the father of the plaintiff or mother never sold their land, my lord, to anybody in paragraph 7 of our plain, my lord. And my lord, my lord, according to the defendant, my lord, appellant, my lord, they have purchased the land. They have mere stated the dates, my lord, but no document, numbers of document or any details was.
If it is unregistered, there will be no
but
number.
it is not registered, my lord. So
if there is no registration, there will be no number.
Yes, my lord. Then it is not registered, my lord. But they have not give any specification or any, because pleadings must be specific, my lord. Next, my lord, I want to draw the attention of your lordship, my lord, to page number, my lord, 23, 3, my lord, of the memo.
Mr. Das.
The judgment, my lord.
Mr. Das, you have to elaborate what according to you is pleadings, because in paragraph 13 they have pleaded. The cell deeds number, the cell deed dates are given.
But
You
how
say
much
it is not
land they have
pleaded.
purchased is not mentioned, my lord. How much land they have purchased, it is not specifically mentioned in their pleading, my lord. They have because about 94 bighas of land are concerned in the suit, my lord. According
okay.
to the plaintiff, my lord,
That is okay, but 11
the
bighas they
father
have
of the
given.
plaintiff expired when they were signed, my lord.
Mr. Das, there are two things. Number one, if you have something in your hand and you can't read, there is something else. But here shown in paragraph 7,
yes, ma'am.
there is a statement given, and if after reading paragraph 7, if you can't read, then we can only suggest that you should go to a doctor. Can I suggest you something more?
Yes, ma'am. And
you've seen paragraph 7 of DW.
Yes, ma'am. I have mentioned about the paragraph 7 of my plain matter.
No.
Paragraph 13.
Yes, madam. Replied that they have participant.
You see, para 11 of the DW of 4.
DW 4.
Yes, ma'am.
They have given 4 bigha, 1 katha, 1 dacha.
Yes,
DW 4.
Yes. Yes, my lord. They have mentioned how much land they have purchased, my lord, in
yes.
that evidence, my lord.
Yes.
But it was not pleaded, my lord.
Oh, acha, not pleaded.
Yes, ma'am.
In the written
This is
statement.
my sir. Yes, ma'am. How much land they have purchased from us?
That is not there. Right.
It is not there, ma'am.
It's not there.
And my lord, why the learned trial court below did not disbelieve their evidence of the DW's, my lord.
Yes.
Yes, ma'am. I want to draw the attention of page number 23, my lord, of the memo.
Page 23.
Yes, my lord. Judgment of the learned trial court.
Page 23. Yes.
Yes, my lord. Yes, ma'am. Again, DW4 in his affidavit had stated that the ancestor of the plaintiff and defendant had 6 sons and so in their plan. They were late so and so. This is not material, my lord. Next, about 7 or 8 lines below. As per the family settlement. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10
Where?
line. As per the
Where?
yes, as per the family settlement, each of the Badar got landed property of 32 bighas, 4 kotha, 14 lessers, and since then they have lived separately and used to look after and maintain separately their respective share of land. The plaintiff father, late Lokhikanto Sharma, during his lifetime, sold away land from his share to different person by executing different sale deeds. Hence, the plaintiff is now possessing 3 bigha, 4 kotha, 19 lessas of land, but denied the fact of possession and managing of the plaintiff land by his late father and by him and his brother. In cross-examination, this DW4 had stated that the plaintiff father, late Lokhikanto Sharma, had expired before his birth. Though in his affidavit, he had stated that late Lokhikanto Sharma had sold away land from his share to different person, but this DW4 in cross-examination had admittedly deposed that he he had not submitted all the sale deed, nor he had taken any step for submitting the same. DW4 further in his evidence on affidavit had stated that the Jamamandi exhibit exhibited by the plaintiff have no mutation of the name of the plaintiff, as he had no land under their patta. But in his cross-examination, he admittedly deposed that plaintiff father name was recorded in the aforesaid mentioned exhibits. So from this kind of evidence, that DW4 there is a doubt in the accuracy of his evidence given in the sheet. So the plea taken by this defendant side that Lokhikanto Sharma during his lifetime sold away some of his land from his share for his treatment is not true. The defendant side, though exhibited the sale deeds, exhibit number B, C, D, E, and F, and have been produced for from proper custody, and these said documents are of more than 30 years old, but their value as evidence must depose upon the corroboration derived from the external circumstances. Mere production without some corroborative evidence is not entitled to any weight. Section 90 of the law of evidence is very much clear that the court may presume that the document purporting to be 30 years old are genuine, not that it must presume then to be shown. In this instant suit, the sale deeds exhibited by the by the presumption of the genuineness had been weakened by the circumstances. That is the findings of the learned trial court below, my lord. And evidence of also in the evidence of section 90, my lord, it is also specifically stated that presumption is not mandatory, my lord, upon the learned court below, my lord. The court may exercise the discretion to presume the document as genuine, my lord, even though it is more than 30 years or 30 years. In the case of Prakash versus Santi Devi, my lord, 2015 for SCC, my lord, page 601, my lord, at para 10, my lord, it is specifically mentioned. It requires to be the provision of section 90 for considering a document to be a genuine, which is more than 30 years, is not mandatory upon the learned court below, my lord. The court may exercise jurisdiction.
What is the citation?
My lord, 2015 for SCC, page 601, related paragraph number 10, my lord. This case was regarding a gift deed, my lord. The gift deed was 29 years, 6 months old, my lord. The court, learned court below, at that case, my lord, considered that the document may be considered as genuine, my lord, because six months is late, my lord. Then the apex court held that the court cannot exercise the jurisdiction arbitrarily, my lord. It must be exercised, my lord, discretionary, my lord. That discretionary is not, does not mean that it may be exercised arbitrarily. Judicially, it must be considered. So, in order to come a judicious decision, my lord, the presumption may also come in presumption under section 90 of the Evidence Act must be also considered judicially, my lord. So, corroboration is required, my lord, because the DW3, who produced before the learned trial court below to corroborate the evidence of the DW4, my lord, does not know about the existence of the deed, my lord. And DW4, my lord, himself also gives evidence during cross-examination against their evidence submitted in evidence on affidavit, my lord. Direct contradictory evidence, my lord, at the time of cross-examination. That is why learned trial court below did not believe the evidence of the PW4, my lord. Mere the document, 30 years document, comes from a proper custody, does not compel the learned trial court below to believe it as genuine, my lord. Paragraph 10, my lord.
My lord, may I cite my lord one decision?
Just let him complete.
Number
2021 2S
2021
2SCC 718 718.
Okay. Anything more?
Yes.
Yes, sir. Yes.
For that, my lord, I would like to write one Supreme Court case, my lord. There is 2021, 2 SCC, page 718.
2021.
2 SCC, page 718. Relevant paragraph is 14. Lordship. In this paragraph, my lord, it was explained why section 90 was incorporated in the Evidence Act, my lord. Because as per your lordship already expressed, my lord, when it was very old document, it's not possible to, my lord, prove those documents. For the genuineness of document has to be accepted. If otherwise, my lord, it was proved. 718.
Yes.
In this
Please read that.
paragraph 14, my lord, I'll explain, my lord. Because it is extremely difficult and sometimes not possible to lead evidence to prove handwriting, signature or execution of old document after lapse of 30 years. In order to obviate on such difficulties to improbabilities to prove execution of an old document, section 90 has been incorporated in the Evidence Act, which does away with the strict rule of proof of private document. Strict rule of proof private documents. Presumption of genuineness may be raised if the document in question are produced from the proper custody. It is, however, the discretion of the court to accept the presumption flowing from section 19. There is, however, no manner of doubt that judicial discretion under section 90 should not be exercised arbitrarily and not be informed by reasons. So in this present case, my lord, the trial court disbelieved the DW4 as he has stated the names of the plaintiff's father, my lord, was not there in the Jamabandi, my lord. It is not regarding the cell deeds which were exhibited, my lord. On this statement, my lord, in cross-examination, the entire evidence of the DW has been discarded regarding the cell deeds, my lord. There is nothing to explain, my lord. There was nothing, my lord, said by the defendant DW4 that these documents were not genuine. It was only the statement which was my learned brother has pointed out regarding the Jamabandi, my lord, not regarding the cell deeds, my lord. And your lordship is already aware, my lord, the Jamabandi is not the title, my lord. Regarding the proof of title, my lord, it is the cell deeds. And there was nothing was suggested that these cell deeds were not my genuine. Whereas the DW has categorically and very specifically mentioned the areas and the deeds, my lord. Although in the WS, my lord, he was not mentioned the areas and cell deed, but the prime basis of the pleadings has been made in the paragraph 11 of the WS, my lord. He has mentioned that some of the some portion of the Sutland has been sold out, my lord.
There are two things operating against you. Number one, in the written statement, the description of land is not given.
Yes.
The second factor which operates against you is the filing of the document in the suit. From the document which is available here, it appears that the documents were first filed in the year 2000. So it is not before the settlement of issues that the documents were filed.
The prior before amendment, my lord. It was before amendment of the CPC, my lord. Before amendment, it is not required.
No. Even earlier, the requirement of the filing of documents are always there.
earlier amendment, but it was not there, my lord.
Yes, the document had to be filed. All documents has to be entered. That came in the year 2000. Your documents came in the year 2000. Therefore, you see, in your pleadings, it is not there. At the time when the plaintiff gave evidence, that evidence started in the year 1996. At that time, the documents were not there. You introduced the documents in your in the record in the year 2000.
No, evidence was given in the 90, suit was 95, my lord.
96, the evidence of plaintiff is there. So at that point of time, the documents were not there. So therefore, the plaintiff had no choice. The document was not there. You
As
can.
per my understanding, my lord, prior to the 2002 amendment, my lord, the requirement of filing documents at the time of
No, that is
suit-
okay. But how long could it have been? Could it
because
have been postponed?
in the earlier, what happened, my lord, we used to file documents in the evidence, my lord. And as per that, my lord, DW has filed the evidence in.
No, you can't take anyone on surprise. Because you see, that would mean that the other side will have no access to your document. This is the filing slip. And down below are the documents.
In the evidence, my lord, we have annexed the documents, my lord, exhibit. Earlier, you used to give the documents, my lord, in the evidence stage, my lord. And on these documents, they have ample opportunity to cross-examine the DW, my lord.
No. You see, the documents are not there. That means when the plaintiff evidence is being tendered, they have got they will not be in a position to say anything about the deed.
Regarding that, my lord, we have pleaded in the WFL, although, my lord, the deed number were not given at that time, but the basis of the pleading has been made in the WS, my lord.
I'm just thinking aloud. How will the defendant take the plea in the written statement if the document is not there? How will he take a plea?
I am the defendant.
No, the plaintiff. Sorry. How will he take a plea in the evidence when in the written statement the reference to the what do you call land is not given, and the document itself is not tendered when the PW starts?
At that time, my lord, before amendment, my lord, as per my respectful submission, the filing of document was not necessary, my lord. But after amendment, my lord, it was mandatory, my lord, to file the relevant document during the filing of the suit or my lord, the evidence, my lord. At that time, we used to file the evidence documents, my lord, at the time of evidence, my lord.
DW4 file evidence on April 7/5/2004, my lord. DW5 evidence on April on 7/5/2004, my lord.
No, during shoot was
No, that time the document was there.
And prior to that, my lord.
No, at that time the document was there. Document has come in 2000.
It was 95 shoot during shoot filing of the suit.
Document has come in 2000.
Means that is the time when, my lord, SDPA stage, my lord. Used to, on that stage we used to file the documents, my lord. That is the SDPA stage, my lord. when we have
That's what I'm saying. It was after the SDBA stage. That's why I'm showing you the date. Your PW was in, PW number 1 was in 96.
no, okay, it was the DW5 in 95, my lord.
PW. SDPH is not different from for the plaintiff and defendant for different stages. Step before plaintiff hearing is only one date, which is before the evidence starts. Both sides will have to take steps, even on earlier times. That's what I am showing you time and again. Your documents came in 2000, but PW1 was in 96. That means before settlement of issues, the documents were not there. That's what I am trying to point out.
2003. 2003. PW1.
PW1 was filed 2003, Lordship.
PW1?
Yes, ma'am. 10/1/2003.
No, 96. This is the PW. PW1 is a Jarikarak evidence. I don't know why it was recorded.
My lord, Modan Sharma, my lord. PW1.
No. First page is PW. First page is PW. PW1 is Jarikarak. I don't know why it has been recorded. Come to PW2. You see the right side is the date. First page.
I have to see, my lord, the filing of PW1, my lord.
Modan sir.
It was 2003, Lordship, PW1.
It's 3, not 96.
No, this one, this PW1.
Why should it 96? I don't know.
I don't know. Regarding most probably this was a Jarikarak regarding service of notice, most probably. Lordship.
Okay.
Most probably, I
Yes,
presume,
ma'am.
my lord.
Okay, pass it on.
That was the PW1. my lord. So at the time of PW1, my lord, documents were there.
The
2000.
documents are there.
Thank you. Origin. GL 137. 137.
Okay, I'm listing it next week for clarification, if any.
My lord, one submission is there, my lord. I reply to it. My lord, my friend has submitted that mutation does not confer title, my lord, but they have not challenged the mutation order passed in favor of them.
No, but still it does not
My
confer
lord,
title.
on the-
Even if it does not challenge, it does not confer title.
Yes, my lord. My lord, it may confer title, my lord, in case of Assam, my lord, because in 1998 for GLT page 137, my lord. In the case of Omiyabala, my lord, this the honorable court held that in case of mutation, it may confer title in case of Assam, my lord. Not this citation may not be applicable in the rest of India, my lord.
What is the citation?
1998 for GLT 137.
1998.
1998 for GLT page 138, my lord.
Para?
Para is not written, my lord. Yes. The sum and substance of the citation is that, my lord. In case of Assam, the mutation is granted in accordance with the procedure
as given in the Assam Land and Revenue Regulation Act, regulation, my lord. So, according to law, as it is, as mutation is granted, it cannot be said that it cannot be cannot confer title, because in order to section 52 of the Assam Land and Revenue Regulation, mutation can be granted if two ingredients are satisfied: one, possession, and second is right, my lord, or title over the land, my lord. So the
98 4 GLT.
1998 volume 4 GLT
138.
136.
No. What is the name of the parties?
Omiyabala, my lord.
Spelling?
AMIYA. Omiyabala. BAL.
Is one word or two words?
My lord.
Amiyabala is one word or two words?
Two word, my lord.
Okay. Submissions of Mr. Sheila Ditila, counsel for the appellant, and Mr. P.P. Das, counsel for the respondents, is concluded. List on Tuesday. Next, for clarification, if any, that may arise after the result of the LCR. Next Tuesday.
One thing left, my lord. Yes, Sri Sharma, my lord. The appellant number 1 has already expired, my lord. Appellant number 1 has already expired. It is in the record, my lord. But he is not substituted, my lord.
Is there any order? Did you bring it to the notice?
Yes, yes.
It is already informed. Inform your lordship, my lord.
Lordship, my lord.
Pardon?
I have already informed your lordship, my lord, regarding the date of the one of the appellant, my lord. Other legal layer survive.
The defendant DW4 mandate himself, my lord. And appellant number 1 in the case.
Other legal layer survive, my lord. We would like to sue survive.
Yes.
I'll go to the LCR. It's being listed next Tuesday.
Yes.
Item 2.
Yeah, please, Your Honor.
My lord, in this case, I am appearing on behalf of the respondents, my lord. And physically, my lord, I am handicapped today because my paper does not tell you with the records, my lord.
But still, it's a whole matter. We are not adjourning.
Yes, my lord. That is true, my lord. I am very sorry, my lord. But in this case, the plaintiff has filed a suit for declaration of right title. My lord, the plaintiff could not prove his title, nor he could file the suit within the time of limitation, my lord.
The plaintiff is appellant is the plaintiff.
No, my lord. Defendant, my lord. Yes, yes, my lord. Appellant is the plaintiff.
Appellant is the plaintiff.
Yes.
আগত কিছু বান্ধি দিব ভিতৰত পেপাৰটো খোলা আছে। But this your this exhibit of DW1 that give deed, that is inadmissible.
Yes, my lord, that is true, my lord. My lord, admitted position, the plaintiff could not prove his title, my lord. He could not show any documents. He claimed to be the owner, but he could not produce any documents. And it is admitted fact that the defendants 4, 5, and 6, they 5, 6, and 7, they were the patta holders. Their patta has been exhibited. Article 64, my lord, is to prove his title first, my lord.
No, he's the what do you call? His grandfather
Yes,
was the patta holder.
Yes, my lord. But
So inheritance is there.
But subsequently, that was sold to the defendant, that property.
No, that's what I'm. I think this is not admissible. You see, this is an unregistered sale deed.
Yes.
How do you get a certified copy of the sale deed? We don't know. You see, this is a certified copy given from some record by this registrar.
But patta is there, my lord. Patta is the name of the.
You see, once the sale deed is not there, gift deed is not there, entry in the patta will be doubtful.
In that case, my lord, my position will be adverse, my lord.
No, but it's not possessory title which has been declared.
Yes.
The title of the plaintiff was extinguished because of this deed. This deed itself is not admissible, so therefore it could not have been done.
Not only on the basis of that deed, my lord, regarding disposition was made prior to 12 years. My lord.
Where is that part in the trial court judgment? I will continue at 2.
Yes, my lord. My difficulty is that my paper does not tell you the reports, my lord.
No, may not be, but
Yes,
you can
ma'am.
still
Yes.
read this evidence. We
Yes,
will
ma'am.
catch up.
Yes.
We cannot tell you. We won't take an offense of that, but we read that.
My lord, I'm sorry. My learned friend is other party. Item 3, it can be taken at 3 p.m. today, because at 2 p.m. I have a fixed matter at court number 70.
Okay, time I can't assure because how much time this matter will take, we don't know.
Yes. But
Not
not
at 2.
before 3 kindly.
Okay.
Obliged. Master.
Two other reasons where the suit was dismissed.
My lord, on the basis of adverse possession, my lord, the petitioner plaintiff could not prove his possession. And they, the PWs, all the PWs, they have stated that the plaintiff was not in possession for about 30 years, 40 years like that, my lord.
That is additional issue number 2.
My lord.
There is additional issue number 2.
Yes, my lord.
But is that finding sustainable? You see, please come to internal page 10 of the trial court judgment.
Yes, my lord. Trial court or appellate court?
No, trial court judgment first. Senior division. In the middle of that page, page 10, internal page 10 of the judgment.
That is issue number 2, 4, and 8. 2, 4, 2,
Yes. Page 10.
Yes, my lord.
A little below the middle. Thus, it is established on admission that the suit line and its admitted description has been originally owned by the deceased Syed Ali Fakir, who had been the grandfather of the plaintiffs. And the plaintiffs, along with pro forma defendant number 1, Amir Ali, had been co-sharers through deceased Syed Ali Fakir. So therefore, the plaintiffs and the defendant number 1 were co-sharers is an admitted fact. But the question is that if one is a co-sharer, then the possession against the others cannot be adverse, because one will be in possession on behalf of others. Who is DW1? He is the defendant number 1.
Defendant number 1.
So adverse possession is claimed by defendant number 1.
Both, my lord. Defendant number 1, 2, 3 in one part and 4, 5, 6, 7 in the other part, my lord.
Okay.
May I get the judgment, my lord?
Yes, read that part only. From there, that is the only issue. If it is adverse position in your favor, then it starts from page that internal page 10, from that part.
From issue number 2. This issue is 9, my lord. Where from the issue starts? Issue 2.
No, that's okay. This part is not in dispute.
Yes, sir.
The actual the first part is pleading. And it says that a land was gifted. 19 bigha, 4 kata, 15 lecha was gifted through Hiba in 1962.
Yes, my lord.
So once that plea is taken, it will be the defendants who will have to prove their gift.
And in doing so, may I read, my lord?
Yes, yes.
He had admitted and disclosed the fact of the claim of the plaintiff through his predecessor and the same original owner, this is Syed Ali Fakir. DW1 took Mordhanya Daw as certified copy of the gifted. On perusal of exhibit Mordhanya Daw, although it is found, has your last got it?
Yes.
On perusal of exhibit Mordhanya Daw, although it is found to be exhibited without any objection, it is found that it is an unregistered deed and defendants fail to prove execution of the said deed by executor, serially copy, for putting his signature. None of the witnesses mentioned within it, including the description, had been examined.
But you see, here again is a question. This, you see, who can issue a certified copy?
Appropriate authority, that is the registration office, my lord.
No, this was unregistered deed. Certified copy could not have been given by the sub-registrar. So what has happened from where I don't know, this is the document. This is the civil judge who has this, what you call this, civil court has issued this certificate copy. Office of the District and Session Judge. Now a
Yes, my
document.
lord. If it is unregistered, there cannot be a certified copy.
No, but you see, this is the document. This document is issued by the civil court. Shistadar of a civil court. District and Session Judge office is issued. This was erroneous because under the civil court rules and orders, civil court, when a document is a part of the documents filed in the suit, can give you a certified copy of the documents which are on record. But that can't be certified copy of those documents. You get uncertified copies, except for court record, because this is a private record under the civil court rules and orders. Criminal is a civil. Because I can show you from an example before I come to this this civil code rules and orders. My examples are always horrible, so excuse me for giving these examples. Now you see, I file a suit. If I'm after a few years, I will be in a position to file. So after a few years, you will please assume that I will file a suit declaring myself to be for a declaration that I am the President of India. And I give a certificate in that suit saying that I am the self-declaration that I am the President of India. Now I get a certified copy from the court of my own document. So whether this certified copy of my own declaration can become an evidence to put me into that position, the answer would be no. A self-declaration or a document which is otherwise not, because 76 says, 76 or 78, it says that the authority with whose custody it is of the Evidence Act. Evidence Act. You see 471 and 472. And 481. 471, 72, and 481. This is civil code rules and orders. 471 says when copies of the record of the court can be obtained, which is before a decree. Supposing plaintiff and a defendant are there in the suit, the defendant wants to get copies of whatever is there on record before decree, that can be done under 471. Now 472 is post decree. Post decree, you see, it is limited to only orders of the court. You can't get copies of documents after that. Document is not entered. Now come to 481. That is the negative clause.
Except public document. Public document can be given. This is a private document.
Therefore, under this three provisions under civil code rules and orders, the document itself becomes inadmissible because of the fact that under this 76 or 78 of the Evidence Act, 79. So 79, I'll just read. The court shall presume to be genuine every document purported to be a certificate, certified copy, or other document which by law is declared to be admissible as evidence of any particular fact and which purports to be duly certified by any officer of the central government or a state government or by any officer in the state of Jammu and Kashmir who is duly authorized thereto by the central government, provided that such document is specifically in the form of so and so. So this is
May not be applicable in this.
This is not applicable. And 78 says proof of other following documents 1, 2, 3, 4, 5. It does not say about private document, which is unregistered document. It doesn't say about that. So civil court issuing a certified copy, it is per se inadmissible. Because if a document which is not admissible, even if there is no objection, if it is admitted, we will not make it an admissible evidence.
It cannot confer any title or right.
No,
That is true, my
I'm not saying that because we have not come to that part. Because the admissibility, we are now discussing only the admissibility.
Yes.
Because is that because the court is the civil code, page 14, this page 11 you were reading.
Yes.
It says that it was admitted without any objection. So even if there is no objection, how far the court can admit into evidence an inadmissible document? But nonetheless, that was discarded by the trial court.
Yes,
Hero was discarded. Because if you say, if you claim adverse possession, then you have to give the date when the adverse possession starts running against the two owner. The date has to be pleaded.
It has been stated in the WS manual.
What is the date of disposition?
My lord, in paragraph number 5 of my WS,
Paragraph 5.
paragraph 5. WS filed by the defendant number 4, 5, 6, and 7. It is like
Four, 5, 6, and 7. Yes.
paragraph number 5.
Paragraph.
In paragraph number 3 is also there, my lord. To some extent, paragraph number 3, my lord. That the plaintiff is not legally entitled for a decree for declaration of right title interest over the suit land, because in the last settlement operation, the suit land has been mutated in the name of the defendant number 6 and late Grador Soika, and the said mutation has been confirmed. For the same reason, the plaintiff case is beyond the jurisdiction of this honorable court. And next paragraph, paragraph 5, my lord. Regard this
Just you are reading from which page?
My internal page is first page of the WS. It does not tell you it, lordship.
No, because in the brief that written statement is not there. The memo appeal does not contain written statement. It contains only a copy of the plaint.
I may be allowed to find out matter from the lower court.
So lower court is there, where this At times the handwriting is very bad. নাই কাৰণ যোৱা ভূমি বন্দোবস্ত বাস্তৱিক কালত 6 নম্বৰ বিবাদী আৰু মৃত গিৰিধৰ শইকীয়াৰ নামত গছৰিভুক্ত মাটি নামজাৰি হয় আৰু উক্ত নামজাৰি হুকুম চূড়ান্ত হয়। মই একেই কাৰণতে বাদীৰ গছৰি মানে আদালৰ বিচাৰৰ সমৰ্থিত Please read paragraph 5. Handwriting at times I'm not being able to follow. What is the English translation of paragraph 4 and 5? Please read again.
4 is not important for limitation, my lord. 5 is important.
Yes.
That as regards the statement made in paragraph number 3 of the plain, the defendant number 4, 5, 6, and 7 submits their reply as follows.
So then it's incorrect then.
Copy has been supplied by the appellant, my lord.
No, I'm giving the original one. It doesn't tally with that. That's why perhaps I have not been able to follow.
No, that is different title suit, my lord. This one.
So different LCR.
No, this part, my lord. Oh, yes, my lord. This is title suit of 3 of 98. But relevant is TS 7 of 99.
TS 7 of 99.
7 of 99. There were 2 cases, my lord. First, this was 3 was filed. It was withdrawn, and subsequently another was filed.
TS 7 of 99. Okay.
Yes.
Oh, that's why. Okay. That's why I was not being able to follow. Where is it? No, the file. Yes, okay. This is, I can follow.
Yeah. In paragraph number 5 and 7, the defendant has stated that they were in possession since 1975 or 72, like that, my lord. And the witness from the PW plaintiff, from their side also it is admitted.
But what is the date pleaded? Address position, there is no date given.
Specific that is not given, but year has been given, my lord.
Where?
Till last 1975, that is paragraph number 7, my lord. May I read, my lord?
Yes.
that during the period of last settlement operation, Syed Ali, father of the performer defendant number 1, before leaving India, sold the suit land along with another adjacent plot measuring 2 bighas, 4 kathas, 15 lasas, and 2 bighas basti land to defendant number 4 and late Giridhar Saikia, accepting exhibiting existing price at the relevant time by executing a Kacha Dolil. As the transaction was made at the time of resettlement of land, mutation was done in the name of the purchaser. Since the date of leaving India by the said vendor, the defendant number 4 and late Giridhar Saikia enjoying possession by doing cultivation and planted fruit-bearing trees and bamboos of different kinds on the Basti land. Till last 1975, the land were under khas possession of defendant number 4 and Giridhar Saikia. And after the said here such possession has been maintained through defendant number 1. Defendant number 1. After the death of co-partners Giridhar Saikia, also in the case of heirs of said man, the same arrangement is prevailing. So since 1975, they have been possessing land. And their name has been mutated by the revenue authority. My lord, may I point out one thing regarding that unregistered deed. It was claimed by the defendant number 1, my lord, not by the 456, and it was rejected by the trial court.
Okay. Your DW number, you are for 456, 4567.
Yes.
Your parties witnesses, who are they?
DW4 himself deposed DW1 most probably. My lord, I am not sure, my lord.
No, if it is defendant number 4, he examined himself as PW4, PW2, DW2, sorry.
Yes.
That will get at page 11 of your of the judgment. So suit was decreed.
Yes.
The appellate court went against him.
Yes. Because the case, my lord, against that two appeals were filed one by defendant number 1, 2, 3, and another by 4, 5, 6, and 7. In appeal, it was reversed, my friend.
The two appeals were adjudicated separately.
No, in the same common judgment.
Title bill 5 and 1.
5 and 1, my friend. 5 of 2006, 1 of 2007.
Please read this discussion on the issues here.
In the appellate or
Appellate order.
after framing of 2 additional issues, my lord.
Yes, basically from paragraph 15.
Yes, my lord. On perusal of the record of title suit number 7 of 1999, it is transpired that appellant defendant severally filed the WS observing his right to file counterclaim if the circumstances demand, and subsequently he filed the counterclaim for the settlement suit length on the ground of adverse possession. The other defendants number 4, 5, 6, and 7, appellants number 1, 2, 3, and 4 also filed their counterclaim claiming right title and interest over the suit length on the ground of adverse possession. Learned counsel for both the appellants advanced their argument on those points in relation of the evidence on record as well as on law points. On the basis of the grounds of appeal and the submission of learned counsel of both the appellants and also on the materials on record, I am going to dispose of both the appeals by this common judgment. Learned trial court decided the issues for delivering the impugned judgment. The issue number 1 is whether there is cause of action for filing the suit. Learned trial court holds that there is a cause of action for filing the suit by the plaintiff. According to the plaintiff, cause of action arose on such and such days, alleging inter alia that when the plaintiff went to plow the suit land on those aforesaid days, the defendants prevented him from plowing, which act of defendants clouded the interest of the plaintiff by denying him to plow on the land which according to plaintiff was under his possession. The cause of action means essential facts consisting the right and its infringement which entitled a person to sue the wrongdoer or defaulted or anyone liable for it. Generally, the cause of action means a bundle of facts, but the facts must give him some right to sue. To prove the cause of action, the plaintiff is to advance his evidence on that point that the cause of action actually arose on those 3 days mentioned above. To prove actual right to sue, my lord, there is some omission, sir. I'm very sorry, my lord, in the typing.
It's okay. This is not filed by you.
Yes.
This is by the appellant. But you see, if you can turn over and come to paragraph 23 of that
Yes.
appellate judgment.
Yes, I'm reading.
Page 11. Now you see here what has happened. Come to down below. PW2 deposed in the middle.
Yes, ma'am. That the suit
PW2 deposed that the suit land was under possession of the plaintiff for last 35 years.
Yes.
PW3 deposed that the suit land was under the possession of the defendants since 14-15 years.
Yes.
And PW4 deposed the land was under the possession of the defendants for the last 40 years.
40 years.
If that being so, it is manifested the suit land under the position of the defendants. Now you see when there are two sets of defendants.
Yes.
One is separate and 4, 5, 5, 6, 7, 8 are different. then the appellate court will have to give a finding which defendant was in possession. Because if it was in the possession of defendant number 1, then it could not have been adverse. They are same family members, co-owners. Possession by a co-owner is never adverse.
It was a claim of the plaintiff, my lord.
No, because in this cause of action, it says that the plaintiff has no legs to stand.
Yes, my lord.
But how can that be?
Because the other witnesses from the plaintiff side, they have stated that they were not in possession, plaintiff.
No, that's what I'm asking you. You see, if it is defendant number 1, he is a co-owner. Which of the defendant was in possession for last 40 years? The finding has to be returned. There can't be a vague finding. Defendants are in possession when there are 8 defendants. There are 2 sets of defendants and their interests are different.
Yes, my lord. It was also claimed by the present respondents, my lord. They have given permissive possession to defendant number 1 to possess that, to cultivate that.
But defendant
So
number 1
that-
is a co-owner. That's the first statement in the plaint. He's a co-owner.
Yes, my lord.
So if he's a co-owner, then if a co-owner gets it, how it can be adverse? There's a difference between co-ownership and a joint owner, what you call joint
My
patta.
lord, that was not the finding, that was only deposed by the PWS, my lord. My lord, the presence is not for the whole area, my lord, only one part.
Okay, what will be that value? Please come to that paragraph again. This finding of the first appellate court. Paragraph 24 onwards. So, is never in position to confirm.
May I read, ma'am?
Yes.
In that view of the matter, in that view, it is my considered view that there is no cause of action or right to suit to the plaintiff is nothing but nullity. I fail to agree with the decree of the learned trial court in deciding the issue number 1, that the plaintiff has cause of action for filing the suit. Next,
Yes.
in view of the above, the issue is decided against the plaintiff. The issue number 2, whether the suit is barred by limitation, was decided by the learned trial court in favor of the plaintiff and hold that this suit was filed within the period of limitation in as much as the cause of action for the plaintiff arose on such and such date, and the case was filed on 9/4/99. Learned counsel for both the appellants had submitted that the learned trial court decided the said issue erroneously and without going through the evidence on record. In other words, their submission is that there was no proper appreciation of the evidence in respect of deciding the issue number 2. In the issue number 1, it has already been discussed that plaintiff failed to prove his possession over the suit land as the witness examined by him belied his claim of possession. It is also on the materials on record that the suit land was under the possession of the defendants for last about 40 years. That being so, filing the suit claiming for right title interest and recovery of possession by the plaintiff on 3/4/99 seems to show that the suit was not filed within the period of 12 years. As per provision of Article 65 of the Limitation Act, the suit claiming for right title and interest and recovery of first possession is to be filed within 12 years of his dispossession. But the plaintiff has miserably failed to prove his possession till filing the suit. That is 9/4/99, when the all PWs deposed that the suit land was under the possession of the defendant for last 40 years. Learned counsel for the appellants relied on a decision reported in AIR 1975, Guwahati 47, in support of his submission. That being so, it is my considered view that the suit is barred by limitation. In that view, I fail to agree with the decision arrived at by the learned trial court in deciding that the suit is filed within the period of limitation. But our High Court judgment is there, my lord. I am reading the headline. May I read the headline of that judgment of our High Court?
No, not required. You can come to paragraph 31.
That being so, it is my considered view that
This is citation is wrong. AR 75, Guwahati 47.
47. It is there, my lord. Regarding possession and title. Principle is that, my lord, he is to prove his title, my lord. As per provision. That being so, it is my considered view that the suit is barred by limitation. In that view, I fail to agree with the decision arrived by the learned trial court in deciding that the suit is filed within the period of limitation. For convenience, I shall take up issue number 3, 4, and 5 together for discussion. Issue number 3, whether the suit is maintainable in its present form and manner. Issue number 4, whether the plaintiff has the right title and interest over the suit land, and his said right has been clouded because of mutation granted in the defendant. Next paragraph, paragraph number 33, he has discussed, my lord.
But you see, when a title is either granted or extinguished on the basis of adverse position, the date from which it begins to run has to be part of the judgment.
Yes, fine. In WS, we have stated that it was from 1975, but in the judgment, it has not been transferred. May I read paragraph number 33 of the judgment?
Yes.
To some extent, he has discussed, my lord. Paragraph number 33.
Yes.
The pleadings and the evidence of both the parties, it is manifested that the plaintiff claimed to be the successor of one Syed Ali Fakir. Syed Ali Fakir was the owner of 17 bighas, 4 kathas, 16 lesas of land, which includes the suit land, as described in the schedule of the plaintiff, comprising of 8 bighas, 4 kathas, 8 lesas. According to the plaintiff, the suit land was given to the plaintiff by his grandfather Said Ali Fakir by execution of the will. But that was not produced, my lord, in the year of 1962. And since then, the suit land was in possession of his father. And on expiry of his father, he was enjoying the possession of the suit land by his uncle Amir Ali, former defendant. And his name was also mutated in the revenue record, which was subsequently cancelled. He has admitted that their mutation was cancelled, my lord. And his suit land was mutated in the name of the defendant of 4, 5, 6, and 7 for the last settlement operation in 1960 to 80. So between 1960 to 80, their names were mutated. It was admitted by the plaintiff, my lord, that the name of the respondents 4, 5, 6, and 7 were mutated. That being so, it is manifested that the time of filing of the suit, the plaintiff had no any title over the suit land. And it is admitted by the plaintiff that we were recorded pattadar. Not only our name appears in the Jamabandi, but we were the patta holders. It is admitted by the WS in my counterclaim. On the other hand, the defendant number 45677 claimed to be the owner of the land by purchase. Their version is that the suit land was sold by Said Ali Fakir to Sabor Ali, and from Sabor Ali, they purchased the suit land, and their names also have been mutated over the suit land. Exhibit Core 1 and its original by Exhibit Core 2 are the Jamabandi showing the suit land in the name of the defendant number 4, 5, 6, and 7. In view of the above, that at the time of filing the suit land, the plaintiffs had no title, no right title over the suit land. The mutation of the land, suit land in favor of the defendant number 4, 5, 6, 7 were proved by defendant number DW1, Sri Nomal Chandra Bora. So they have admitted that we are the quota holders and our names were recorded in the Jamabandi manner. They have never approached before the revenue authority for cancellation of our name.
Who are these people?
My lord.
This Giridhar Saikia, Niren Saikia, Biman Saikia.
4, 5, 6, and 7, my lord.
What is the investor?
My lord. 4 investor, 5 Kiran, 6 Biman, 7 Ratan.
No. Giridhar Saikia, Niren Saikia, Biman Saikia, and Ratan Saikia.
Giridhar was the father of respondent number 5, 6, 7, probably, my lord. I'm not sure now.
Showing this. This is the pata.
Yes, sir.
Now, in one of the document, it says that Giridhar and this Dimbeswar, they are brothers.
Yes, my lord. Patta was in the name of Giridhar and 4 others. Giridhar is the father of the petitioner.
No, not
What?
father. Father is someone else. That you will find in either of the earlier page or the back page of that document. Yes, previous page. Yes, in this page. The Besser and they are sons of so and so.
WS, there is something, my lord.
No, because in this case, I'm not being able to follow the facts.
My lord, in WS we have stated, my lord, but land was mutated in name of defend number 6 and late Giridhar's again. Defend number 6 is
Two. Can you read this date? I can't even read this date. This date. Read. Can you read? No. Okay.
in the reading, my lord.
Yes. What is the date?
22/9. Probably it is 80.
No, it can't be 80. No, the Patta date is written only in the back, not here.
So it is a target. Seems to be 80, but
80.
80.
Okay.
22/9, 1980.
80. So again, it is barred by that is perfected from that day. Well, Dr. Goswami, I'm asking you because of the reason this patta is for 30 years.
Yes, my lord.
The period of patta is 76 to 2006. So date of issuance of patta is 1980. How can that happen? Patta issued with retrospective effect.
My lord. It cannot be issued with retrospective. My lord.
I don't know, but this is what I'm understanding. If I'm reading this correctly, 1976. It's 1st April 1976 to 2006, 31st March.
Yes.
That is the settlement period. But this was issued, if you say it was issued on 22/9/80, that means it is being given from a back date. Retrospective effect patta.
May I go to the record again, my lord?
See this. First paragraph of this patta. From 1st April 1976 to 31 March 2006. 30 years. But next date you are saying that patta was issued in 1980, so it is given a retrospective effect. And the date of issue is down below. That also, the year I can't read. Dr. Goswami, I'm fixing some other day because this is where I'm finding the facts is not very clear.
Yes, my lord. In this case, I will have to go to the records, my lord.
No, please go through it because I'm finding it very difficult to follow the facts.
My lord, may I pray for a photocopy of these documents?
Photocopy you may not get it, but you'll have to apply a certified copy because photocopy will not be permitted. We'll make that application.
Otherwise, my lord, the designation is very. Designation is similar. Tell you the records. In that case, it will be a bit easier. So I will apply for certified copy, my lord.
You fix it after vacation because I
Yes, my lord.
not be able to follow this. None of these will call for the appellant. Our Dr. P. Goswami Kannan, counsel for the respondent, is present. Next, in course of his submission, it appears that the documents which are required to be read in evidence. From the documents which are from the documentary evidence, the finding cannot be finding of the Learned First Appellate Court cannot be seamlessly connected. Full stop. Therefore, on the prayer made by Honorable Counsel for the respondents, the year for respondents were 4 to 7. 4 to 7. The matter stands adjourned to do so as to enable him to go through the documentary exhibits. Stop. Matter stands adjourned today. List. After vacation, give a date. After vacation, give a date.
6/11.
And the matter kept as part matter.
No, I'm not keeping it parted because what you call, I'll be forgetting it by then. And Dr. Goswami, I can't be blamed for that. Because once you don't keep it in constant touch with the file, I won't remember. Because I've not made any notes. Without my note, I'll not be able to remember anything. Even if you give this file to me tomorrow, I'll not be able to recollect unless I can connect it with my notes. So that is a bad habit.
You also can remember all those things, but we can't.
No, I may recollect, but I will not remember. Dr. Goswami, by the way, in the what you call, your brother, I forgot the name. Deep. What is doing now?
He's already retired from that college.
He's retired.
Yes.
Okay. So he's doing something now.
No, nothing.
Okay. His brother is my classmate, so different. Okay, but facing means that retired. This is doesn't what you call. Yeah, okay.
I'll get that.
I was just thinking that the next question we should also say is that when did he retire?
No, that may not be an appropriate question. But then, what you call the your question would be then how come I went out? Item 16. Yes,
We
you've
were
been
kept
very,
waiting
very
well.
patiently waiting.
And this is the second appeal arising out of a petition filed by the appellant under Order 21 Rule 97. The substantial questions of law framed in this case are primarily based on the fact that I was not given the opportunity to place my case because it was filed on a particular day. Next day, we just moved it, and the following day, our order was passed, final order.
So that sequence.
Madam, sequence Lordship will kindly go to the application first, madam. That is at page 22.
Page?
Page 22, my lord, starts.
Yes.
Lordship may now turn to page 40.
You are a third party.
My lord. Page 40 is the affidavit which shows the date of filing, 20th of June, 2020.
Okay, just before that, can you show me the judgment and decree first? Against which order 90, this section 97 application, this order for 21, 96, 97, 98 application was filed. What sort of degree was there? You have a copy of the degree?
Decree for recovery, yes. Decree for recovery of possession money. Declaration of title and recovery of possession. I'm sorry, madam. It says suit against the tenant. Defendants in that case were, according to the plaintiffs, tenants. Although the tenant challenged the relationship, etc., but then it was ultimately decreed by this.
Okay, it's a tenancy case.
Tenancy case.
So, Mr. Das is the landlord.
Yes. Yes.
Yes. No.
But as far as the present appellant is concerned, they have claimed title by prescription of law of adverse possession. Because according to them, they have been there, and his father was also there for about
Then
9
no substantial question is made out.
minutes.
Then no substantial question of admission of the appeal is made out. You see, because if you have an independent title, that can be independently agitated, not in the suit against a tenant.
No, I'm not against the tenant. Well, I'm
No. In his suit against a tenant,
My lord.
you can't claim a title. You have to independently fight it.
Well, we filed independently. Then we were directed to file an order 2197. We came here once before December 4.
Your suit was dismissed.
No,
it's pending.
Suit is pending.
If suit is pending, you will have to go there. You can't have parallel adjudication. A suit as well as order 2197, which again is a suit.
Actually, they want stay of the execution.
I understand. No, that is why I started with that. What was the decree? Now, if I understand the nature of decree, then I would be able to apply my mind.
Page 18. And page 18 is the order.
1-8.
1-8.
You have a copy of that CRP
The court
petition? Just show it to me.
Seventeen.
This execution case is between whom and whom? What is the name of the parties? The decree holder and the judgment debtor?
Yes.
Who are they?
Respondent number 1 and the other respondent.
No, just give me the names.
Yes. Respondent number 1 is my lord.
Joyamata Burwa is the decree holder.
Is the decree holder and is the judgment debtor?
Judgment debtor Putuli Singha, Namrata Devi,
So they are,
Mamata Devi, or all others.
so 11, 12 and 13.
Yes. Hearing.
Oh, here it will be 2, 3 and 4.
2, 3, 4,
5, 6, 7, 8.
5, 6, 7, 8. Nirodpur Singha, Alpur Singha, Pranjal Pratim Singha, Pankaj Singha. Nirodpur Singha. Yes. There.
There 5, 6, 7 are my lord. 10 in judgment details.
But then you tell us.
No. Just one
Before-
information. So far as the suit is concerned, there they have filed an application under Order 711, and this further proceeding the suit has been kept in abeyance.
Okay. No, just I'm reading your plaint.
My lord, plain.
After that, I am asking you a question.
My lord.
In the plaint, you have made this 23 people as parties, and you are claiming adverse position of Schedule B land.
Yes, my lord.
Correct.
My lord.
That means some semblance of right title interest all these 23 people have.
No, my lord, so far as the owner is concerned, naturally I have to admit his ownership.
No, that's not the question. You see, when you are in a suit for adverse position, when you are making 23 people as defendants, they must have some semblance of right, title, or interest. Otherwise, they would not be a party.
Yes, yes. Naturally.
Correct. Some interest they have. Now, from them, out of these people, if one is evicted,
Yes.
how you will be affected in the suit?
No, but,
Your one person is gone. Now you have to fight against 22.
no, but
So he's helping you, in fact.
I'm positioned in different land. They are positioned in different land. Plots are different. The persons who are possessing as tenant there, I'm not claiming that part. I'm sorry, we are claiming the entire.
You are claiming that also. Okay. So these people, have you inducted them as tenant?
Yes.
You have inducted. Where is that statement? Otherwise, your suit will fail.
Yes.
How can you claim against your tenant adverse position?
No, this claim of adverse possession is not against the tenant.
But you have not said that in your prayer is not mentioned. You are not distinguished.
It is there, man.
No, it's not. First prayer is declaring plaintiff has a required right and interest of be over adverse position.
In the prayer, man.
Yes.
Plaintiff. My lord, so far as the suit is concerned, in the suit, we are challenging the decree itself for the simple reason that if the decree stands against me, then the status of the tenant also remains.
I don't know. TS 17 or 23 is what?
Filed by him.
Hmm? 17.
Who is Manas Changmai? You are holding big for Manas Changmai.
Yes, ma'am.
Then Manas Changmai is the plaintiff in title suit 17 or 23.
Yes.
There are 23 defendants in the copy which I am holding.
Yes, ma'am.
Part of their CRP.
Yes.
Correct.
Yes.
First prayer is that declaring plaintiff has a required right, title, and interest.
Yes.
By adverse position.
Yes.
Now, please explain to me how against a tenant, a landlord can claim adverse position.
No, but so far against the tenant, I am claiming that I am the owner, and his status as a tenant will remain.
Can't be. You see the prayer. Your prayer is before you.
Yes, prayer is declaring that the plaintiff has acquired right and interest over the CPB land by way of adverse position.
Yes.
Yes.
So if he is a tenant
My lord.
in your own land, you are the landlord.
My lord.
Yes,
I
am in the process of learning.
I have understood your process.
No, I am not. It's not a question. I am in the process of learning. A landlord claiming adverse position against a title of adverse position against a tenant.
No, I'm not saying that. My lord, Schedule B land is the land over which, unless I become an owner, he will not become my tenant. I'll become an owner and he will remain as a tenant. I'm not disputing. I'm claiming that he's my tenant. In the application that I filed under Order 21/97, my whole case is that they are my tenants.
No, then your prayer would be that so and so, please declare that he is so and so is my tenant. That would be your prayer. To claim adverse position against a tenant. I am in the process of learning.
That's what I'm saying. The prayer is not given in
Happy words.
Yes, but then otherwise, my prayer is that in this.
Maybe it was not written in happy hours.
Maybe it was written in the morning during daylight. So my submission before Lordship is the whole, I should be declared a landlord, owner in respect of the whole land. And my stand is very clear in my Order 21/97 also that they are the tenants whom I have inducted. And so far as the ownership claim is concerned by way of adverse position, that is against the landlord.
You see,
Man.
Mr. Mazumdar, the tenant contests the suit.
Tenant?
Whoever is the tenant of Mr. Das is
Man.
contesting a suit.
Man.
And in the suit, he will not say that who has inducted him as tenant.
Man.
He will contest the suit of the landlord.
He is
So
claiming,
tenant
he is claiming to be the owner, my lord.
That's why tenant has forgotten you,
No, but to both of us.
both of us,
Both of
and therefore you are claiming adverse position against the tenant.
No, that's what my prayer may not be so correctly worded, my lord. But then my claim is that about the
No, you see, your claim when Mr. Das takes over your land,
my lord.
your devolution of right would be under order 22 rule 10.
My submission will be like this, madam. My stand all throughout has been that I am the owner of the land. And in order 21 to 97 also, I have claimed that I am the owner. Now, so far as tenant is concerned, since my stand itself says that they are my tenants, so far as they are concerned, my declaration of right for the tenants will be that I am the landlord and in the capacity of an owner of the land. And unless I get the declaration of title and ownership over the entire plot of land,
This suit of Mr. Das was filed when 1989.
89. Huh?
Okay. So for since 89,
My lord.
today we are in 23.
My lord.
This your suit was filed when?
It was 23.
23.
My lord.
How many years? 24 years. 24 or 34? 34 years. After 34 years, you realize that he was your tenant. What is your age now?
43.
43. Very good. So you become a landlord when you were how many years old?
No, my father was there earlier.
Your father was there earlier. Then there's no substantial question of law which arises. If you succeed in your suit against the interest of the his tenant, Mr. Das's tenant, you get yourself him substituted under Order 22 to 10. That there's a devolution of interest in favor of the plaintiff, and therefore he steps into the shoes of the tenant.
Landlord.
Definitely, if he becomes the what you call, if he is able to evict him, the judgment debtor.
Yes. Judgment debtor.
If he is able to, if he is successful in doing so,
Yes.
then your right would be to substitute Mr. Das under Order 22 to 10 on devolution of his interest on the in respect of the tenant.
So far as the since I am claiming ownership over the
No, till now you see that for 34 years,
My lord.
it is the plaintiff, Mr. Das, who is contesting the suit to evict him.
Yes.
So why should he not get the fruit of the decree? If you want to protect yourself in the suit, to protect yourself, will record your submission to reserve your right to impede the judgment decree holder.
Here is a case where
To substitute him as the in place of the tenant.
no, well, here is a case where the tenants are also in possession. I am also in possession of a part of a land. I am also independently possessing a part of the land.
The tenant's place you are also possessing.
Yes, tenants are in a separate house. I am in a separate house.
No, he's not wanting to evict you. It's not Mr. Das's case that he wants to evict Mr. Mazumdar.
No, but then he wants eviction from the entire plot of land. Problem is there, man.
Show us from your pleadings how you have stated that it is the suit premises where you are seeking a declaration of title.
Yes.
Where is the decree in this case?
They are seeking eviction from Schedule B land, and that comprises of 1 bigha, 1 lecha, and the 4 katha over which I am possessing is part of this 1 bigha.
From where you are reading?
I'm reading from the judgment of the trial court. In
Which
their,
page?
In
Page?
their suit. My lord, page 42.
42. Of this second appeal.
No, my lord. Page 42 of the trial court judgment separately given.
No, no.
Last but one page, my lord. Schedule B. At the bottom, land measuring 1 bigha, 1 nature covered by tag number so covered by PP number so of Sibsagar town, Nagar Mahal Mauja.
No. 77.
On the paragraph 2, Lord will find the entire land is described in Schedule A.
Yes, and a part of land is Schedule B.
Schedule B. And
Schedule B is the one where he was given as a tenant.
Yes.
He has subletted to
Minor.
different people.
Minor. So page Schedule B is 1 bigha, 1 nisa, and the 4 katha of land. Trial court dismissed the suit, my lord. It is the first of the court which declared the suit by setting aside the judgment of the trial court.
See, it seems to be very unlikely.
Minor.
The reason is very simple.
Minor.
Suit is of 89.
Yes.
The plaintiff has made 15 people as defendants and is contesting against all of them. And you are the landlord, you don't know that somebody is evicting someone from last 34 years. Very unlikely.
December 20, the Nazir came for.
No, that's okay. You see, that part of the, I'm not on that. But in, you see, I am in possession of a flat in a apartment building. My personal house is an apartment building in a commercial area. If a suit is filed in the entire colony against one, I think in our society we will know about it. if there is a suit against for eviction against any person living in the entire colony, I think everybody will know about it in the locality. That the landlord of so and so has filed a suit against so and so. 15 people have been proceeded in an eviction suit, and nobody told you. You are the landowner. Nobody told you that there is a suit pending by some third party.
We have taken a plea of connivance.
And in connivance,
Between the landlord and the
no, I understand, but connivance is of 34 years.
Yes.
34 years, people are going to court, coming back.
And the order sheet will reflect how the matter has proceeded.
No,
for 34 years.
I'm just asking. I'm not believing
Yes,
it for this reason.
Normally, that is why, madam, in the year 2021, a judgment was passed by the Supreme Court saying that in a case of this nature, when the suit is for recovery of possession, court should exercise its power under order.
No, we have done it. We have amended our civil court rules and orders.
My lord.
118 capital A to capital C has been introduced
My lord.
in the civil court rules and orders.
So the party should be examined to find out who is in possession. That
No,
is
no, but you see, the tenant who are fighting the suit,
My lord.
for 34 years, they don't disclose that they have somebody else as a landlord.
No, but they have taken a plea of adverse possession, my lord. The tenants.
So adverse position would run against you also. And you are claiming in your suit adverse position against your own tenant.
No, adverse possession. I'm not claiming that I'm repeat this. I mean, the prayer is such. The prayer is slightly different in so far as language is concerned.
I've just read your plain.
My lord.
Tenant is claiming adverse position against the landlord, and you are claiming against your tenant.
No, I'm claiming adverse possession against the owner, person, plaintiff.
No, perhaps after you amend, you may again file your order 21 or 97 again. But in this stage, I don't think there's a second appeal in this case for admission made out.
My lord, in this suit also, I cannot pay for injunction. They have taken an order of keeping against the entire proceedings in the suit.
But it can't be helped.
Yes, there is an order.
No, it can't be helped. It's a necessary evil when you are in a civil suit.
And in this case, Lord will examine how the court has proceeded. I filed the application today, tomorrow the order is passed. If I factually aver that I am in adverse position, at least, and the defendant doesn't file any reply, file any objection, that means my pleadings are admitted. And the court passes an order against me. They have not filed any objection, madam, to my petition.
No, correct. You see, the court has a power to this order to 41/97. That must be something which is where a bona fide claim has to be shown.
And the finding of the court is, my lord, that I have not been able to produce any document that I am in possession. Municipal receipt I have to show.
So whatever, but if you are in position, you have to have something.
Madam, I am saying position this appellate stage, they have filed a reply. They have not used a single word to say that I am not in position. I can show from I have the next display, their reply.
So show us that sequence to show us.
Yes. Dr. was saying that page 22 is my petition, madam.
Page 23.
22.
22, yes.
Madam. And the order was passed, as I have submitted earlier. Order was passed on the following day, that is on 21st, page 47, madam.
47.
Yes. Then when we filed the appeal, this appeal matter at page 65, they have filed an objection matter, which you will find at page 84. Page 84, they have filed the objection matter. In the entire objection, they are not disputing that I am in possession. Page 84, madam.
84.
In the entire objection, they are only giving the stages of what application was filed, and nothing on merit, and not disputing at all the averments made in the petition, where I have claimed adverse position, where I have claimed that I am in possession for last so many years. Nothing, man.
No, because you see, this is an application and objection against under order 21. Sorry, for stay. It's
No,
an
ma'am.
application for stay.
No, man. My application under order 21 to 97, although the first sentence says like that, it is otherwise an objection to my case. They have for the first time opened their case.
No, page 84.
My lord.
You are showing us this the first line is the petition for
My
stay.
first line, I have also read it. I also got that kind of impression. Lordship may kindly see the cross title in the matter of an objection on behalf of respondent number 1 against the miscellaneous appeal filed by the appellant.
Appeal is against the rejection of stay.
Yes, but no. Appeal is against the final order passed in order 21 to 97. Miscellaneous appeal 6 of 23 is the appeal against the decree passed by the executive court. And they have stated about the entire case, but not disputing our position and our claim for adverse position.
You see page 48 also same thing.
My lord.
So and so for stay the proceeding of execution.
My lord, that is why these are the difficulties, my lord. Otherwise, page 48, although it is mentioned like that, subsequently, Lordship will find the court has entered into the merit of the case, and this is the order on merit of the petition itself.
Mr. Das,
My lord.
I did not follow that earlier. But if order 21 rule 97 is dismissed like that, it is a procedural irregularity.
Order 21, Rule 97, he has to show first that he is claiming adverse position against the other party, opposite party. There has to be pleading. That is what has been discussed by the trial court as well as the appellate court. That he wants to read certain documents, certain evidence, but that is not required under order 21 rule 103, because that is the court has to decide on its own. It is not to be decided as a suit as such. While order 21 rule 97, 98, 99, 103, 101.
It must proceed like a suit.
Yes.
That
No.
is the legal requirement.
Legal requirement is that it should be determined by the court dealing with the application and not by a separate suit. Not by a separate suit. But that does not mean, my lord, it should be decided as a suit.
I'm sorry, man. This is Supreme Court has said it should be decided as a suit.
That's what I understand.
Well, Brahmadev Choudhury
Yes,
judgment.
sir, let him complete. Let his task complete.
No, I'm sorry.
And rule 102, 103, my lord. Although it is an order, it has been made a decree by legal fiction. That's why the appeal and the second appeal. Therefore, it is not to be decided as a suit as such. In that case, not by a separate suit. Here in this case, my lord, your lordship pleased to see that initially he filed a title suit. After that, title suit, when it was pending, as your lordship pleased to see, my lord, his petition, that is made clear. Page 24. At page 32, my lord. Paragraph 15, page 32, down below. Paragraph 15.
32.
Page 32.
of this memo of appeal. That the petitioner as possessor of the Schedule A land, a plot of land, since last 90 years, has now preferred the title suit 17 of 2023, inter alia praying for declaring that the petitioner has acquired a right title interest over the Schedule B land by adverse possession and so. That the paragraph 16 there, that the suit land of the title suit number so and the land which is to be executed in the execution case are same. Then, my lord, your lordship is to see the next page, paragraph 17, that as the aforementioned title execution case number 2 of 18 was in progress, therefore the petitioners having no option left preferred Miss J case number 46 against the opposite parties inter alia, praying for stay of the proceedings of the title execution case number so as the petitioner was in possession so and he had preferred title suit. Against that, my lord, that was dismissed, that case. And against that, he preferred a civil division petition 78 of 2023. And therein, the order was passed that he has a remedy of under Order 21, Rule 97, 98, 99, all that. And thereafter he has filed it. But it is not the direction of the court as such to file when he has filed the suit as such. Your lordship, please to see Order 21, Rule 104. Every order made under Rule 101 or Rule 103 shall be subject to the result of any suit that may be pending on the date of commencement of the proceeding in which such order is made. If in such suit, the party against whom the order under 101 or Rule 103 is made has sought to establish a right which he claims to the present possession of the property. Therefore, this order will be subject to the decision of the suit. That he has filed the suit earlier. Now, in order that he did not get possibly, I don't know, an order of injunction, he prepared an application for stay of the suit. That was rejected. And against that, he came before the Honorable Court. Honorable Court said, no, your remedy is not there. Your remedy is that if you are a third party claiming the right of possession, but your remedy is there. Therefore, he has filed this application. Now he has filed this application. What does it mean to say? That he has been in possession for the last 93 years, along with his father. My lord, wrong possession is not necessarily adverse. Otherwise, it is inherently improbable. Your lordship has plus the finding of the trial court and the appellate court. Para 16 of the appellate court judgment, my lord. Page 159. Paragraph 18, 159. Appellant has categorically averred that his father, Khorgeshwar Sangmai, came into possession of the vacant portion of the land in 1930. Petitioner's statement in paragraph 3 of the petition is not specific. If his father had given one katha, I can skip it over. Paragraph 19, my lord. As stated above, appellant has not stated the dates of contended giving one kasa, one lecha of land and Assam type house. Also, appellant has not let the court know the dates of birth and death of his father, Khargeshwar Changmai, so as to give opportunity to believe that Khargeshwar Changmai came into possession of the Schedule A land since 1930. Appellant is aged 43 years on the relevant date, that is 2023. So his year of birth is 80. As per contention in paragraph 5 of the petition, Khargeshwar Sangmai used to possess the B schedule land since 1930. Though details of other family members, including mother and siblings of appellant, is not stated, it is presumed that the appellant's birthplace is Schedule A land. Then what was his father's age in 1930? Even if Khargeshwar Sangmai was born in 1930, his age in 1980 was 50 years. As per contention in paragraph 15 of the petition, appellant petitioner is in possession of the Schedule A land for the last 90 years. As appellant cannot be in possession for 90 years at his age of 43 years, and so prior to him, his father was in possession. In this way, to substantiate his contention, appellant's father was obviously in possession since 1930, thereby to mean that he was minimum 18 years of age in 1930. Again, if the appellant's father was less than 50 years of age in 1980, he cannot be existed in 1930 to possess the scheduled land. If the appellant's father is taken to be 18 years of age at the time of possession of the disputed land, and as the appellant is aged 43 years at present, his father at the time of birth was 68 years old. This discussion makes it clear that the appellant in his petition has failed to establish exact date of adverse possession disputed land. And as there is no contention of the appellant's willingness and readiness to prove the fact of possession of the disputed land. Otherwise, my lord, paragraph 16, it has been contended what is about adverse possession. The learned appellate court has taken note of Supreme Court decision as paragraph 17, 16, 17, page 158.
You know what I've opened? I've opened a website in the net. Is called oldest.org. The one of the 8 youngest people who have been kings. 8 years is Murad IV. He reigned from 1823 to 1640. Ottoman.
Israel.
Then the celebrity, what you call pyramid, the tomb of King Tutankhamen. Tutankhamen became king when he was 9.
No, Akbar became
1332 to 1323. No, I am showing you youngest. These are King Oyo of Oyo of Taro. He was 3 years when he became a king. and he's presently reigning. He's still he's the king of which place I don't know. Then one is Qing dynasty, 5 years, 2 years. Yu Yi.
Oh,
2 years.
2 years.
King Sohuza II, he was king of Swaziland at the age of 1.
Swaziland.
Henry VI, Henry VI, he was aged 9 months when he became the king of England. Alfonso XIII, he just became king on the at the time of his birth. He took birth and became a king. So this is history. So what was his age is an unnecessary exercise the court is doing.
No,
without evidence. You see, this is only surmises. When there's no there's no respondent, when this inquiry was not even made, for a trial court to jump into conclusion that this was the probable age, that can't be permitted.
No,
Lordship may just have a look at this. I'm just sorry to interrupt. Just have a look at the judgment of Patna High Court of 2022. Just one small paragraph of some relevance.
Yeah, I'll come to it. Let Mr. Das finish.
No, about this that not be treated as a suit.
No, it's a suit because there's a Supreme Court judgment on this.
Yes, no evidence was recorded. Nothing. They have not filed any reply. I am only on that matter.
No, we'll come to that.
What is the entire petition under Order 21, Rule 97 is that they have been in wrong possession. Wrong possession is not in adverse possession. It has to show, that has to be a pleading, and thereafter the evidence will come. First the pleading that it was continuous, it was open, it was hostile to the true owner. That has to be pleading. But instead, he states in all the paragraphs at page, it starts at page 22 and ends at page 40. The entire scheme of the petition shows that he has been under wrong possession, which is inherently improbable. That is what has been shown by the trial court and the appellate court from the pleadings itself, not with the evidences. These are not required from the evidences. Inherently improbable that can be shown from the pleadings of the party. No objection was there from my side, of course. But the pleadings, inherent improbability of the pleadings can be gone into. And that has been gone into by the learned trial court, the executing court, and the appellate court. And the finding is, now the question that comes here, that it should be decided as a suit. My lord, section 100, your lordship knows, the substantial question of law involved in the appeal. If it is not involved in the appeal. Involved in the appeal means, my lord, that it will clinch the issue. It will tilt the balance on the other side. But if it is inherently improbable from the pleadings of the parties, then the question of substantial question of law involved in the appeal does not arise. That may be a substantial question of law in other cases.
From your submission, can I take it as a principle of law? You see, let us say a suit is filed. Rightly or wrongly, somebody claims absurd thing in the suit. Now, is the trial court has power to dismiss a suit on the improbability of the claim? Let us say that I am in a bad state of mind.
No,
immediately.
Order 7, Rule 11, CPC.
No, that's
Cause
what
of
I'm-
action.
No,
is
that's what
there.
I'm saying. You see, somebody may have made a very absurd claim. Let us say A is bad state of mind. He says that he's the owner of what do you call the Parliament building. He files a suit. I'm the owner of the Parliament building. My great grandfather, he owned the land, and therefore I'll prove it in due course. And the government of India has usurped my land and build a parliament therein. Let us say absurd case made out, absolutely absurd. Now, does the trial court has power to dismiss the suit in limine without issuing a notice to the other side, without summons, without any pleading? He will just scrutinize the plaint and then say absurd, dismissed.
No, if there notices to be issued. Notices
No,
to
but
be issued.
Here what has happened?
No, we got the notice. We were there. And the argument was made. Because it is the executing court.
Notice was not issued.
Huh?
No notice was.
It's not issued.
No, next day itself. I filed it on 20th, 21 I moved it, 22 the final order was passed. They are not in the picture, man.
Notice, formal notice need not go because it is the executing court. On that day, we were there. And we didn't know it.
When I'm just sorry to interrupt one factual thing, man. Factually, what has happened when I filed the petition, man, sorry to tell your lordship, man. Initially, the solicitor refused to take the petition on the ground that in execution cases, no such petition is allowed to be taken. Now, somehow we filed, brought it in the court. Now, in the court, when the matter came, and I'm now compelled to say all these things. In the court, when the petition was placed, I'm sorry to say, the presiding officer immediately stood up and went to the chamber. Then from the chamber, the Peskar came. Court master came and informed us, whatever you have to say, you go before the chamber. My learned friend was present. Now he was outside the chamber and he was informed that you can go now. And my learned friend was physically present. He moved the matter. And this next day, the final order came. No reply, no evidence, nothing. The Brahmadev Chaudhary, my lord, on the Supreme Court says, S.B. Majumdar, my lord, that it will be a adjudicated process. And if now he is not given the opportunity of placing his case, bringing the evidence, it will be a violation of the principles of natural justice, my lord. Para 9 of this Brahmadev judgment, lordship, just
No,
for
just let me see last complete.
yes.
What I am trying to urge upon your lordship, that there must be a complete pleading. Pleading means, my lord, statement of the material fact. And in case of adverse possession, your lordship knows. 779. It has been noted by the appellate court in paragraph 17, page 158. I am holding the book. 2004 10 SCC 779. Paragraph 17. This is in paragraph 10 possibly.
Just a moment. Just open this. Yes. The AIR 2023 SC 2567. TV. Look on the TV. TV. Monitor. AIR 2023 SC 2567. You can also open in Supreme today. If you have Supreme today also. Supreme today. Supreme today is also there. Here you will find AIR, not SCC, AIR.
Yeah. SCC.
AIR Supreme Court. Twenty 2567.
2567.
Then search by name Gini, JINI. Nominal. No. Nominal index. No, not this. It should be nominal. Find by name. No, not this. Not this. Just say first one, search. Type Gini, JINI. JINI. Next word is Dhanraj Gir, DHAN RAJ GIR. No, one word. GIR. Search. No, then close this. Start the Supreme today. Close this app. Supreme today. Nidhyana is not there. No, not getting it.
My Supreme Court I have got.
Supreme is opening, but here it's not opening. I wanted to show it to him.
From his Supreme Court I got it.
Show it to Mr. Das. This is Supreme Court.
Ah,
Para 17, 28, and 29.
Paragraph, my lord?
17.
Yes.
Because here it says, it refers to the language of Order 21, Rule 97,
Yes.
and says in the middle, the provisions of Rule 97, 101, and 98 of Order 21 enable the executing court to adjudicate the inter se claims of the decree holder and third parties in execution claim. So this two sides are required. That is number one.
Enabling the executive court.
And it's a complete code by itself.
Now I come to page 25.
Para, madam.
Para?
25.
Para 25.
25. Determine the place.
Oh, sorry. I'm sorry. I'm sorry.
There are 20.
It will be 28.
Yes.
Here in the middle, it says the claim regarding right, title, interest, and respect of the respective shares in decretal property as raised by the respondents cannot be thrown out at the threshold, since it is well within their rights to contest the application under Order 21, Rule 97 CPC filed by the appellants. Since evidence is required to be led before it, the executing court so and so. So therefore,
This is the relevant.
I justified in holding the objection to be maintainable at this, not in the sense that the receipt cannot execute against them, but in the sense that final receipt has been set up for inquiry to be conducted, and posting the matter for evidence by the party. The final receipt is made up. Final receipt is set up. So the final receipt case has been set up to assure that upon determination of the question,
yeah, next is 29.
will be adjudged to hop, skip, and jump to reach the Supreme Court for a better reason. When the remedy is
So it challenged before the High Court. So that is the only 3 lines. Correct. So it should not go to Supreme Court without there being a challenge before the High Court. That is the only 3 lines I wanted to show.
But in paragraph 28, no, 28.
Here only says that by leading evidence. That is the only part.
But in this sense, but last 3 lines possibly 4 lines. Since evidence is required to be laid before it, the executing court was well nigh justified in holding the objections to be maintainable at this stage, not in the sense that the decree cannot be executed against them, but in the sense that a prima facie case has been set up for an inquiry to be conducted and posting the matter for evidence to be read by the party. Prima facie case is to be said. Prima facie to be satisfied. Here in this case, my lord, prima facie the court was not satisfied. Prima facie case had been set up. In that case, my lord, the Supreme Court, that case, the executing court had entertained the application. Against that, my lord, the other party had moved the Supreme Court. It took him on judgment. Dhanraj, Jeannie Dhanraj.
Jeannie Dhanraj versus
Thomas Matthew.
23 SC game.
SCC 9.
Yeah.
Supreme ARSC 2567.
ARSC 256.
The product is licensed to be reported there. Wow.
That 1997 judgment on which reliance has been placed even in this case, which your lordship is saying, says that the principles of natural justice has to be followed. That Brahmadev chose it. He cannot be condemned unheard.
I may also say, my lord, this is a ploy by the judgment debtor. He is the number 5 person. Originally, the judgment debtors themselves filed an application under Section 47. That was in 2019. That was dismissed. They came here. That was also dismissed. They came to went to the Supreme Court. That was also dismissed. And that the matter ended there. The second case was one Parikshit Pathak and Debajit Pathak filed an application. In the same way, my lord, that was rejected, and the first appeal was filed, second appeal, because the second appeal was filed, and
are those materials there on record? Are those materials available in this record?
In this record, it's not there. But in the High Court, it is there. In the High Court, it is there.
Okay, you can give the numbers. We'll try to have it.
CRP number 39 of 2019. CRP 39 of 2019 actual number. I am giving him a number. CRP 39 of 2019. I could get.
Yes, yes, 39. It's RSA. Miller person. Dismissed.
Civil division about.
So that's all, Mr. Das?
Yes.
That's all? You have to say anything more?
But so far as the adverse position is concerned, I wanted to show my lord page 158. That has been quoted by the Learned Appellate Court. Paragraph 16, 17. Plea of adverse position is not a pure question of law, but a blended one of law and fact. Therefore, a person who claims adverse position should show that on what date he came into possession, B, what was the nature of his position, C, whether the factum of possession was known to the other party, how long his possession has been continued, E, his possession was open and undisturbed. A person pleading adverse possession has no equities in his favor, since he is trying to defeat the right of the true owner. It is for him to clearly plead and establish all facts necessary to establish his position. Therefore, the question, my lord, of reading evidence will arise if there are pleadings. Your lordship knows, my lord, no evidence can be looked into if there are no pleadings in that respect. The entire petition under Order 21, Rule 97 shows that he has been in wrong position. That much, nothing more.
What is this TS 24 of 2005? What is that suit?
24 of 2000. It's statute 24 of 2005. 24 of 2005.
It was filed by them, my lord, against a person who is possessing one cut-off land.
Against one cut-off land.
Out of the scheduled plot land.
Out of schedule?
Land.
A land or B land? A land.
Out of one.
24. দরকার নাই এগুলা। এইটু তাতায় আসবে।
Discussion CRP 39. তাৰপিছত CRP IO 106 তাৰপিছত RSA 199 106 9 CRP CRP को भी add करो तो CRP number
Hey, which question? Anita.
Okay.
Second, well, last question, last time. The second appeal is heard only on the substantial questions of law involved in the appeal. No such question arises herein. The questions that has been framed, that these provisions have not been resorted to, that may be decided in an appropriate matter, appropriate case, but not involved herein. This appeal does not involve any substantial question of law, so as to render the appeal to be admitted. Secondly, my lord, they have filed an IA also. What is the prayer in the IA? To stay the execution, to stay the judgment and order of the trial of the executing court and the appellate court. That has been dismissed. Nothing to be stayed. And or they have also stated that proceedings of the title execution case number 2 of 18 during the pendency of the accompanying appeal should also be stayed. Well, if that is stayed, that will amount to staying my decree obtained in the High Court in 2018. that will amount to.
No. Whatever be the consequences, but if the execution, takes away his right, even the High Court decree, when the jurisdiction is conferred in arising out of an application or order 21 to 98, I would have jurisdiction to stay the High Court judgment also.
That is correct. But
Although it has been affirmed by the Supreme Court by dismissal of SLP, I would still have that jurisdiction.
But my lord, they have also prayed for stay of the dismissal of their appeal. That cannot be.
That cannot be.
And my lord, your lordship, I think 104, it takes the precedents of the suit filed by them earlier. That is there because that order 21 rule 104 says that this order will be subject to the decision in the suit pending on the date of the application. And admittedly, that suit was pending. And this is still pending. Of course, it has been kept in abeyance because of the order that can be opened. Because of the suit, my lord, this application is not maintainable. That is my answer. And my lord, long back when we had joined, it is on the lighter side. We are told that I have not seen the case law, but from seniors we are told that it is easier. PB Council had said long back that it is easier in India to get a decree than to execute it. I have not seen the case law.
No, because you see, there's another fact or another facet to it. When the suits are filed, contested and allowed or dismissed, more than that, you find when this objection to execution under section 47 are filed, then better category of seniors, they take control. So therefore is the best brain which is now working.
Much obliged, brother.
So when everything is lost, Mr. Mazumdar is appeared.
And I'm only trying.
Okay. Yes, Mr. Mazumdar, you were trying to show us this judgment.
This judgment only
to
this counter the submission where the Honorable Patna High Court has said in para 6 manner, the scope of petition filed under para 6 manner in the middle. The scope of the petition filed under Order 21, Rule 97 of the CPC and the procedure prescribed under Order 98 and 100 of the CPC are well established, and if any objection under Order 21, Rule 97 CPC is filed by a person who is not a party in the suit, the same shall be decided as if the suit is being decided by the concerned executive court. And later on again, my lord, line about 4th from bottom. It's a continuation of the next sentence and says that the legislature has introduced the concept of adjudication, and the courts have taken consistent view that the adjudication would make it similar to a suit. My lordship will consider.
So this takes away my good time in the afternoon. So
since it is for admission today, anyway, this Brahmadev Chaudhary also lordship will consider that para.
Which one?
Brahmadev Chaudhary.
Brahmadev Chaudhary.
97.3 SCC.
Yes, which para?
Para 9 minor, where minor, towards the end it says that would obviously result in irreparable injury to such obstructionist whose grievance would go overboard without being considered on merits and such obstruction would be condemned totally unheard. Such an order of the executing court therefore would fail also on the ground of non-compliance of the basic principles of natural justice. Para 9. That's all.
Para 9 is in page 703. After that,
Yes.
where were you reading?
Well, I'm reading from page 704 possibly, my lord, just above the paragraph 10. On the somewhat in the middle, my lord, on the right hand side, that would, lordship is got, my lord.
That would.
Yes, from there, my lord, I'm reading. And then it further goes to say, my lord, that on the contrary, the statutory scheme envisaged by Order 21 Rule 97 CPC, as discussed earlier, clearly guards against such a pitfall and provides a statutory remedy both to the decree holder as well as to the obstructionist to have their respective say in the matter and to get proper adjudication before the executing court. And it is that adjudication which, subject to the hierarchy of appeals, would remain binding between the parties to such proceedings, and separate suit would be barred with a view to seeing that multiplicity of proceedings and parallel proceedings are avoided, and the gamut of law laid down by Order 21 Rule 97 to 103 would remain a complete code and the sole remedy for the parties concerned to have their grievances once and for all finally resolved in execution proceedings themselves. And this has been referred and in fact relied on in the subsequent judgment which your lordship has just. In fact, the line which your lordship has showed in the judgment of Gini is the submission that I am making there. It will be it has to be an adjudicative process. There was no adjudication at all. I filed a petition, next day the order was passed.
That is what is troubling me. Let us see.
Next day. I was not even told that, see, you are placing this petition, but I am going to finally dispose of it. Who, I'm not sharing everything my learned friend has experienced there. It was very unfortunate experience there. And that's all.
Okay. I'll examine this and pass for this in the chambers.
Mal. There is a statement we have made in the state petition. They are going to execute tomorrow or day after tomorrow, madam.
Yes.
Madam.
But you still have not answered that. How would you be prejudiced? Supposing the execution goes on, how would you be prejudiced?
My lord, they will recover the possession of the entire land. I am possessing the land. I'll be dispossessed, my lord. But that is my only concern. I'll be dispossessed. And my lord, just one more submission.
Just a moment.
My lord. And that is why, my lord, in their objection, they have not said.
No, just a moment.
My lord.
Fusion position.
If you can come to paragraph 15 at page, paragraph 15 of your plaint,
Plaint, man.
of your own suit.
Of my suit, no? How much suit is it? How much suit of plaint? How much?
I have your copy. You need it again?
Para 11, man. Para 11.
Paragraph 15 of your plaint.
Yes.
Page serial 13.
Yes. Yes.
Yes. Here you say,
Man.
the father of the plaintiff, third line,
Man.
after coming into possession of the vacant Schedule B land, had constructed residential house and shops over it. The defendant number 11 to 23 had been in possession of the Schedule B land only as a tenant, has no right over it. And other defendant number 1 got his name mutated in the entire Schedule A land without having any physical possession over the Schedule A land. So now you are claiming that it's your own admission that it is the defendant number 11 to 23 who are in possession of the Schedule B land.
11 to 23 are tenants.
No, I understand.
Man.
But your physical possession is not there. It's your own admission. You're physically not there.
No, I'm physically there, man.
But that's what I'm reading.
Well, I've got another house, man.
I don't know this.
Yes.
You see, this is inconsistent.
No,
I have a house and the land of Schedule B is possessed by 11 to 23.
My lord,
Yes.
there are, my lord, 2, 3, 4 houses. Four houses.
Show me from this.
Yes.
I have shown you which I read. You showed me from the plaint where you have said that you have a own house.
Well, para 25 over this petition under order 2197.
No. In your plaint, you see, if you take two consistent stand in the two
Yes.
statements, two pleadings.
Well, para 16 at of page 14, man.
Page 14, yes.
That as mentioned about the plaintiff at the very initial stage had handed over possession of land measuring 1 kata, 1 less out of Schedule A land to Jatin Singha and Nandi Sinha, leaving behind the Schedule B land in the hand of the plaintiff. Defendant number 1, despite procuring decree for eviction of the Schedule A land plot, very conveniently chose to execute the decree only over land possessed by the plaintiff for last many years, thereby leaving the rest of the land in the hands of the defendant number 11 to 23. Further, the civil Nazir and the Lord Mandal also have been aiding the defendants for illegally evicting the plaintiff from the Schedule B land by considering vital facts. The act of defendant number 1 clearly reveals its ill intention of taking over the possession of Schedule B land by procuring a decree from the court by misleading it. Hence, it is a fit case for immediate intervention.
Where's the copy of decree in this copy of decree? Where is it? Where it is there?
Well, just now you furnished a copy of the judgment.
This CRP.
No, well, separately we have.
That copy of plaint.
No, but judgment also we have. Decree. Judgment.
This judgment of title appeal.
Yes, ma'am. Yes, because suit was dismissed. Suit was dismissed.
No, suit land is not here. It will be in the plaint.
Plaint.
Decree doesn't have a description of suit land.
Possibly It is there, madam. Some decree.
You have a copy of the decree, Mr. Das, with you?
Not today, but other cases, we've got the judgments and plaints and all.
Decree or execution petition, anywhere you will get the description of land. Anywhere from where I can get the description of land.
Right.
On which the decree is to be executed.
Yes.
Either a writ, copy of the writ.
Copy of the writ or
No, not tomorrow, because if I am to give the order today,
No.
I need it today. By WhatsApp, you can get it and give it to my court master.
No, you too. It is a grant to print page but photo decree to page
Anything from which I can get the description of land.
But if I get my letter, I will hand it over to.
Give it to his WhatsApp number.
Madam, we have submitted a copy of the amended plan that will contain.
I got
Amended?
Copy of the plan.
Ah, yes.
Degree.
Yes, yes, yes.
Schedule B, madam.
Yes, it will be there.
Yes, ma'am.
Schedule B land is 1 bigha 1 katha.
We are proposing only 4 katha. There is a finding, madam, that only 4 katha is available.
No, no, you are showing us this. That is why I wanted to look at the description. You are just now showing us that copy of plaint. Para 15 we were referring to.
Oh, whatever.
Para 16 you were saying.
My lord, yes. My lord, should kindly see page 13 of this plane. Para 15, we are saying that total is schedule A land and subsequently schedule B plot of land for more than 6. So I am concerned with schedule B. Now page 20 of the plane plot will find schedule B, only 4 katas. And rest, even if they want to evict also, I have got no objection. Page 20, internal man.
No, no. You see, that's not the point which I am trying to understand. In the copy of the plaint which you have given me,
yes,
schedule B land is 1 katha 1 lecha.
Lord, if I may place your lordship.
Sorry, 1 bigha 1 katha.
Schedule A.
Schedule B.
No, A is 1 bigger 1 katha. Page 20, man.
No, schedule B is 1 bigha 1 katha. Schedule A is 2 bigha 2 katha.
Also is holding the plaint of it.
This plaint you have given me, I am holding this only.
It is their plaint.
Ah, yes. From this is, you see, schedule B is the land where from where it will be evicted.
Not the entire schedule land.
Schedule A land.
Schedule B land.
No, no. Of the original plaint, you will be evicted from where?
Portion of schedule B land. A portion of schedule B land. And that schedule B land manner there is described in schedule A of this manner. That 1 bigger 1 katha of my side. My lord, schedule B of their plane is schedule A of our plane, and we are claiming possession over schedule B of our plane, which is only 4
This
kata.
4 kata.
Right.
Okay. Okay.
And it remains, my lord, paragraph 16 of at page 33, my lord. It says the suit land in the title suit number 17 of 23, and the land which is sought to be executed in the execution case are same.
Yes. Yes. That's what he's saying. And out of this land, he is in possession of 4 kathas of land.
Yes. 4 kathas of land means, my lord, 1 katha remains only. Because we have total land is 1 bigha, 1 lecha. Huh?
1 bigha. No. 2 bigha, 2 lechas. In your plaint, please look at your plaint. You say that he is to be evicted from the suit land.
Yes.
Suit land is how much?
1 bigha.
Is it 2 bigha or it is 1 bigha? What is the suit land? Schedule B land has been leased out. So you're really asking for schedule B. In the prayer, it is not there. But in para 3 of your plaint, you say that it is schedule B land. You have to, in the plaint, the prayer, it is not there. So 1 bigha, 1 katha. Okay.
I will check it up in the evening, my lord, along with my old records.
Okay.
And if possible, my lord, I will hand over the through WhatsApp to the bench clerk, my lord.
To the court master.
To the court master.
Okay.
All right.
Try to pass on this. Yes, this election matter is there.
ABC of the CPC. I still bow my head down to it.
Yes.
My lord, make a small request, my lord. I was referring for item number 12, my lord. The lordship can kindly post it after the application.
Wait for some time. My court master will take up one by one. But this is election matter. I will take it up by precedence. Other matters will be rolled over. The court master will take care of it. Yes.
My lord. That
you just hear a glimpse of his submission because of the fact that this period of limitation he has explained. I
Yes.
think you better hear it from
Yes.
Mr. Pathak in short.
Issue was, since the election petitioner said that I am covered by the apex court order. So taking that to be the basis, my first endeavor was that even if we go by the apex court order, it is barred by limitation. So limitation, but the stamp report
This is 1984.
1984.
Yes.
So my first limb of argument that even assuming that the apex court order applies in the matter.
Just a moment again. I'll take a 5-minute break and come back.
My lord.
Sitting too tight is now pinching the leg. Just I'll take a 2-minute break and come back. The air conditioning,